All right, we're live. We're here on January 10th this morning, a joint session between the Senate and House Judiciary Committees looking at public safety and access to justice. And we have a number of witnesses to get through this morning, but really by way of introduction, we're kind of at the end of the pipeline here dealing with the criminal justice system, and really the solutions that are out there are preventative, involving additional treatment for substance use disorder, mental health, homelessness, people being unhoused. There's lots of root causes of crime that we don't get to actually deal with here. But once there are offenses being committed, that's when the criminal justice system comes into play. So that's just wanted to frame that. But we're going to start with Commissioner Morrison, unless you have something introductory. So we'll start with Commissioner Morrison. Thank you very much for being here.
Good morning. Thank you, sir. Thank you, senators and representatives. I'm happy to be here with you today. My name is Jennifer Morrison, and I'm the Commissioner of Public Safety. I'm joined today by a member of our policy team, Assistant General Counsel Tucker Jones. And we're only going to take a few minutes of your time, so this is the delay is totally okay because we're going to be relatively brief, or at least I am. To touch on some wave tops related to the current public safety landscape in Vermont. And I will say that I wasn't entirely clear exactly what you wanted to hear from us, so I thought I'd tell you what I've been hearing all summer and fall in the run up to this session as we go around the state and interact with folks. And we certainly look forward to more in-depth conversations as the session progresses. To begin with, violent crime and crimes typically associated with the illicit drug trade are up, and Tucker will have more on that. Across the state, we're hearing from Vermonters, and that includes community leaders, law enforcement, business owners, and everyday citizens. And they are fed up and frustrated with what is happening in their communities, and they are asking for help. In some communities, I would describe it as fear and despair. The biggest challenge that the law enforcement officers on the street are facing right now is crime related to illicit drug use, abuse, and trafficking. This, coupled with the ongoing staffing shortages, certainly presents challenges of varying degrees from every jurisdiction. A common refrain that we are hearing from all over the state that there is a lack of accountability in the system. We're hearing from arrestees that Vermont has a reputation for being soft on crime, and that our catch and release policies are well known in source cities across the Northeast and the Mid-Atlantic region. We are hearing a lot about the harm done in communities by repeat offenders, and I could go on, but undoubtedly you all have been hearing similar things from your constituents. In the short term, the law enforcement community will continue to aggressively seek out and arrest those who prey on Vermont's most vulnerable for profit. These arrests must be accompanied by certain swift and fair consequences. And we must be realistic that we cannot arrest our way out of this epidemic of drug addiction and the attendant violent crime that comes with drug addiction. In addition to investigations and arrests, we need coherent policies and strategies that reduce the demand for illicit drugs. The supply side of the equation will be infinite. There will always be another profiteer lined up, ready to sling dope to Vermonters who want it. So let's focus on reducing the demand. Vermont has leaned in heavily to harm reduction strategies for 10 years now, and this is a vital part of the solution. Harm reduction is a key piece of this puzzle. But yet we still have record overdose deaths, and we have increasing violent crime related to the drug trade. So perhaps a piece of the puzzle is missing. When we treat drug addiction as only a public health issue, we ignore the real harm being done in communities by those who are addicted to drugs and the dealers who bring with them a culture of violence and organized criminal activity. We're sort of in a moment of reconciling the intersection of public health and public safety as it relates to this issue, and we need to answer some very important questions before we continue to throw out more solutions. What is the problem we are trying to solve? I think we need consensus on what we're trying to achieve with our policies and programs. We need a common operating picture of what the scope of the problem is and what the conditions really are in our communities. We need to diagnose the problems before we write any more prescriptions to cure them. This is going to require policymakers, public officials, and communities to get real and get on the same page. We need to have honest conversations about what healthy, resilient, safe communities look like. And it is my humble opinion that we need to stop normalizing addiction and figure out what the missing piece or pieces to the puzzles are that will help us get our substance use, abuse, and overdose rates down. We also need to rebrand Vermont so that it is no longer known as open for business by drug dealers and others who operate for profit, frequently with impunity. The administration has been working across agencies and departments to tackle this problem for over a year, and we need your help. Please acknowledge the scope of the public safety problems we are facing, and please help us answer the questions I just posed. And as we contemplate those questions, we would ask that you please address the lack of legal tools to quickly intervene and stop behavior harming our community. Strong, cohesive communities where citizens feel safe enjoying their neighborhood and public spaces are part of the solution, no matter what the problem is. And I'm now going to turn things over to Tucker Jones for a little more detail on those wave shots.
Thank you.
Good morning, everyone. So yeah, is that all right with you, Mr. Chair? I can just transition in directly in my comments as well.
Yeah, please do, and just introduce or identify yourself for the record.
Yeah, of course. Good morning, senators. Good morning, representatives. My name's Tucker Jones. I'm an attorney at the Department of Public Safety, and it's good to see you all this morning. Thank you for the opportunity to appear remotely. Traveling in this morning was not going to be tenable for me, so I appreciate the opportunity to appear this way. I do have some general framing comments in my written notes here on two topics, drugs and repeat criminal behavior. I know each topic could be 3 days of discussion, but I'll run through both topics in succession quickly here. I don't have any comments this morning on specific bill language. The purpose of my comments are to help policymakers develop some consensus on the nature, the scope, and the severity of some of the public safety challenges the state is facing right now. Some of these comments I've mentioned in other forums recently, and you may have heard part of them before. So the first topic is drugs. As the pandemic and the backlog clear, the underlying drivers of the trends in crime and overdose fatalities are still present. The pandemic and the court backlog appear to be an exacerbating factor, but not the underlying drivers of these trends that we're seeing. One of these drivers is the so-called third wave of the opioid crisis, fentanyl. And fentanyl is now in every glassine bag in Vermont. 100% of substances in glassine bags tested positive for fentanyl or a fentanyl analog at the Vermont Forensic Lab in 2022. Fentanyl is replacing heroin in the illicit market, with heroin only being found in less than half of the tested glassine bags in 2022 in Vermont. The fentanyl heroin balance has flipped since 2018. In 2018, only 43% of glassine bags contained fentanyl and 100% contained heroin. Additionally, to be aware of, in 2023, 56% of heroin fentanyl cases also contained xylazine. This is up from 12% in 2021. As you know, fentanyl is up to 50 times stronger and often cheaper than heroin. It's highly potent and it's inexpensive. Demand is high and it is driving supply. According to the 2022 report from the Federal Commission on Combating Synthetic Opioid Trafficking, the pull of demand continues to drive the supply of synthetic opioids. And according to the same report, synthetic opioids offer economic and tactical advantages that allow criminals to vastly outpace enforcement efforts. We know that the forces of supply and demand in the illicit opioid market account for some portion of the crime trends we are seeing. And I'm assuming that between your two committees, you have familiarity at this point with the National Incident-Based Reporting System data for Vermont on crime trends for the past few years. But if you don't, I'm happy to go into that as well. But specific to the connection between the illicit opioid market and crime trends, according to recent statistics from the Vermont Intelligence Center, prior to 2022, the rate of drug-involved violence remained below 25%. Since then, the Vermont Intelligence Center indicates that the rate of drug-involved violence has increased significantly, with drugs being identified as the primary motivating factor in 44% of homicides investigated by the Vermont State Police in 2023. Statistics this year from the Narcotics Investigation Unit are up. Sale cases increased 17% in 2023 from the year before. Arrests increased 30%, and firearm seizures increased 57%. There is no indication that the destructive force of fentanyl is going to abate this decade. In the first 2 decades of the 2000s, up to 2020, about 600,000 people died from an opioid overdose in the United States. A model developed for the Stanford Lancet Commission on the North American opioid crisis projects that this decade, from 2020 to 2029, opioid deaths will total 1.2 million people in the United States if no new action is taken to address the epidemic. So twice as many deaths are anticipated in half the amount of time. We're now in the middle of that decade. Obviously, this is a significant public policy issue across the country. Because demand is driving supply, we have been focusing recently on understanding the best public policy response to address demand. I will share with you some of the framing questions that I proposed at a recent panel discussion on this topic regarding the government response to demand. Those questions include, is there policymaker consensus that addiction results in significant harm to individuals and significant harm to communities? For some, the answer to this question is self-evident, but I mention it because the disease model of addiction is helpful in many ways, but it does not account for the harm to communities caused by addiction, and it does not provide the public policy answers to that harm. The second question is there policymaker consensus that external pressure, including legal pressure for individuals to end problematic drug use and obtain treatment, is appropriate and necessary when individuals engage in behavior that undermines public safety due to an untreated substance use disorder? So put another way, should government policy on providing opportunity for treatment be fundamentally passive in nature or proactive? And under what circumstances, if any, should treatment be mandated? For any given, and the third question is, for any given public policy you are considering, does that policy advance the goal of actually reducing the size of the addicted population? Now, as I said, I think we could unpack even those 3 questions for 3 days and discuss them in much more detail. But in the interest of time, what I'll do is I'll just run into the second topic.
Before you do, a question from Senator Sears.
Yeah, a couple
other questions as well.
I have a question and a comment. First of all, I'd like to ask Legislative Counsel, and I don't know if anybody's here from Leg Counsel today.
Yeah, couldn't get anybody.
I need accurate crime statistics. I think it is, in this discussion, it's vital that we have something accurate. Because I've heard that we're still the safest state in the nation. I've heard we're 20th or whatever it was. So as with any statistics, you can find one that fits the narrative. And I really think we need someplace where we can get accurate statistics. I don't feel comfortable with that. I'm uncomfortable with part of the conversation from, as a representative of Bennington County and surrounding towns in Wyndham County. I am very upset about the conversation continues on about treatment. I do not have any methadone treatment in Bennington County, none. People in Bennington County have to go to Rutland, Brattleboro, or North Adams, Mass. Those are both areas where they are riding in buses with other people who have addiction issues, and it frequently creates problems. Additionally, and I think this is both legislative and administration's fault. Additionally, when somebody tries to get into treatment, there aren't enough treatment beds or slots in outpatient clinics available. So we can mandate treatment if we want, but we better have treatment available. I do believe that there is some benefit to court mandating treatment, but it better be right at the start. It can't be 6 months after the event that brought them to court. It has to be right then and there. That's when people are most amenable to treatment. Studies over the years, I'm talking about 40 years ago, studies indicated that. I worked in a drug program in 71. Worked in a drug treatment program for the Vermont Department of Corrections. That's what we knew then. And here we are 50 years later, I guess, yeah, about that. With the same subject, only stronger drugs and more potent drugs and more overdose deaths. So I think those things have to be part of the equation. The legislature and the administration, obviously, we're waiting to see the governor's budget. But if the governor's budget doesn't contain treatment on demand, then the legislature is going to need to do it, because when somebody's arrested, that is the time they're most amenable to treatment. And you better have it available for them then, because 3 weeks later is too late. And that's been true for 50 years. So those are my comments and questions, and I hope we take that in that vein, that we all have to work together.
Absolutely, sir, and thank you for those comments. I have no response for somebody else's portion of the state portfolio on that. However, I can tell you that we are working across the state enterprise to come up with solutions to meet people where they are, as you said, whether it's that moment of arrest or in the wake of an interdiction of the drug supply in a community, bringing in mobile resources to basically have treatment on demand. Also, we're looking at models that involve EMS being able to distribute MAT in the communities to meet people where they are. So I hear you. I agree with you. It's something we're already working on. And I appreciate your comments. I'll carry it back to our team. We meet actually right after this at 10 a.m. every Wednesday. So certainly we'll carry that message forward.
Thank you.
You're welcome, sir.
Senator Bachowski.
Yeah, I have a couple of things as well, and I agree with Senator Sears that we can't really claim that treatment and harm reduction don't work if we haven't fully invested in those systems. I'd love to see the reports, Tucker, that you're referencing on our committee page. I went to look and they're not there. So the statistics that you referenced, if you could get them to us so we can put them up, that would be fantastic.
I'll do that.
Thank you. And then my other question, my understanding, and I've heard from multiple people, that the backlog is actually increasing, not decreasing. So I'm curious if that, I know you referenced that as the backlog decreases, we're not seeing a reduction, but my understanding is the backlog, in fact, has not decreased. Can somebody answer that for me?
Yes, we will be, Representative Levon asked us to kind of address specifically measurements in terms of that. We're happy to try to answer now, or if you'd like to, I think we're scheduled at.
Yeah, we're going to go in depth in that issue. So
perfect. I just, like Senator Sears had said, I want to make sure that the statistics and the facts we're basing things on are in fact the actual statistics and facts, and not just what people are kind of like feeling is happening. And plenty of places around the world have really fully embraced substance use as a public health issue with very different results than we're having. They've seen extreme success in the reduction of violence. So I just really want to make sure that whatever we're talking about is really holistic and well-rounded and grounded in making sure that we're keeping everyone alive and getting people the treatment that they need. And that is all I really have to add. In addition to what Senator Sears has said, looking up some crime research, it does still show that Vermont is one of the safest states in the nation. So crime is up across the nation. This is not a Vermont-specific problem.
Appreciate that.
Senator Byhovsky, I just want to respond to that and to say that we in no way meant to infer or say that harm reduction and prevention strategies don't work. My comments were meant to indicate that despite leaning into these strategies, perhaps there's still a piece of the puzzle that is missing. So those are crucial parts of a holistic approach to drug addiction and the attendant problems that creates and spill over into the community. And by all means, we are not disinterested in keeping addicted persons alive by any stretch. We want to keep all people alive, but we also want all people to feel safe in their community, because sometimes when we focus only on the public health side of addiction, we forget that there's real disorder, crime, and fear that's happening because of drug addiction in our community. So it's about having a holistic view and creating a shared common operating picture of what the situation is, as you described, getting the stats, and what are we trying to achieve?
So, Barbara.
So one other factor that would be, and I echo my colleagues who spoke before about harm reduction and treatment and data. So we were hearing yesterday related to retail theft and shoplifting, which some of our witnesses were tying into drug use, that in some cases, law enforcement is not doing, not restraining orders, what's the?
Trespass orders.
No trespass orders. And that made me think about also the law enforcement responses and law enforcement vacancies across the state and factoring that in so that when we're looking at what's happening, we're considering, as Senator Sears said, people who can't get into treatment, and also looking at where vacancies or the inability of our local law enforcement offices and or the state police are not able to respond to things that they used to respond to. And that's shifting perception and response. That's the first question.
I can't speak for any community other than our own in terms of law enforcement response to crimes. I can tell you that if I reflect on my experience as a police chief in Burlington and Colchester, it's more complicated than just the number of officers I have assigned to any shift. So it is unlikely that we would not respond to a crime in progress or even to a late reported crime. What can become a complicating factor is the perception that a law enforcement agency or even an individual law enforcement officer has about the willingness to prosecute those crimes, because there's a lot of work that goes into citing someone or arresting someone, drawing up the appropriate paperwork, going through the process to have it feel that it's not going to be prosecuted or not taken seriously. So it's more complicated. There's prosecutorial discretion mixed in with staffing numbers, mixed in with what are the priority calls in the area at any given time. And it gets further complicated by what is corporate policy at some of these larger retailers who sometimes don't want to provide a statement to assist us with prosecution. So it's a very complicated question that you just asked, even though on its face it seems pretty simple.
Thank you. And I know we'll hear from state attorneys later, so I'm assuming we'll deal with that. So I have one other question, which I think is for Tucker, which is you were talking about both of you were talking about the public health problem and the public safety problem. Obviously, addiction is a health issue. No two ways about it. But when somebody does something else illegal, they punch somebody, they kill somebody, then there is a criminal issue. So I guess I'm wondering, why do you, like, people who struggle with addiction who aren't hurting anybody, maybe they're loitering and making people uncomfortable, but to me, making people uncomfortable if they're not harming anybody is not a crime. So I guess I'm wondering if you can speak more to why it seems like the way our laws are, if somebody's breaking the law, then obviously we're dealing with them in the criminal justice system, and that sweeps a lot of people who are struggling with addiction in. But where is it not feeling clear for you that I'm missing something?
I don't know what you're missing. I don't know what your question is exactly, but I will make this observation that in our criminal justice system, there is a very strong presumption in Vermont of release upon arraignment. And for individuals who are suffering from an acute substance use disorder, there does not appear to be effective mechanisms to intervene and provide assistance to that individual immediately. And instead, what we are doing is waiting till the ultimate disposition of the case in order to ensure that that individual obtains the services that they really need. And that is a disconnect between the criminal justice system and the actual needs of addicted brains that we're all trying to reconcile, I think.
Well,
And
I think Senator Sears made the point that until we really offer on-demand treatment to people without having to get on a bus and we need to make it easy to get help in our state. And we know we're not doing that. We know that waiting 3 weeks we're losing people. People are dying in the meantime. So, but that's not, like, I think you're going to find agreement here. What I'm hearing you both say is that we need to look at other responses related to public safety. And I don't really get what you're saying we need to do for public safety.
So right now, when we encounter someone for chronic low-level crimes, say, I'll just use the Church Street Marketplace as an example, because I think we can all visualize it, right? We give someone a citation that's an invitation to appear in court, and it's 6 to 12 weeks down the road to their arraignment. It is not a deterrent to behavior. They are literally back exactly in that same spot, stealing, breaking things, arguing, getting into shoving matches with friends, well, colleagues, associates, whatever you want to call them. And there is no timely, certain, swift way to intervene in these behaviors. We do not put people in jail. We don't have mandatory treatment. And we are literally giving people citation after citation. I think Tim LD is in the room, so I think he'll be able to speak to the number of open dockets that some of our familiar faces have around the state. And those people are certainly addicted and ill in that way. To only focus on the public health side of it ignores the harm that is happening to the downtowns, which are the economic engines of our communities. And it ignores the fact that other people trying to use that shared space feel unsafe around repeated retail theft, fighting, and other things like that. So the comment was simply, well, it is very clear to say we need timely, which we don't currently have, timely tools with certain outcomes and a level of accountability that currently doesn't exist. And I'll also echo what Tucker said, which is, even as we talk about citations to go to court weeks down the road or months down the road, that doesn't work with an addicted brain. Like, that's not something that's going to prevent them from turning around the next afternoon and doing more of the same.
So it sounds like we can agree that we need to get more resources to the judiciary so that we can have, as you know, the ability to see this through as quickly as possible. And I think that needs to be named and as well, because I think that's like the biggest resource that could make a difference in terms of SWIFT.
That certainly could be a part of it. We certainly need to make conditions of release have some teeth so that when people are allowed the privilege of staying in the community instead of being incarcerated for crimes, that if they violate those conditions of release, that there are consequences in a timely manner. So making conditions of release have some teeth, and dealing with the issue of repeat offenders in a more, perhaps a streamlined way or an expedited way, could certainly have some community benefit to protect the other members of the community who feel unsafe.
Thank you.
So we're going to have one more question from Senator Wachowski, but we are already running significantly behind, and we're certainly not going to solve the conditions of release question or treatment availability. And we're trying to move to focus, this is to set us up for framework. Certainly, this is very important discussion and actually very critical work that needs to be done. But Senator Wachowski.
So my understanding is that our detained population has actually been climbing and we're over 400. So, and I don't know, Commissioner Morrison, if you are able to answer that or if I need to bring DOC will be here later. I'm also curious if you're aware that there's a fair amount of research that shows just 36 hours of being incarcerated increases the rates of recidivism in the community. And so I don't know if I have concern about pretrial detention for more people, knowing that such a short period of time actually increases the risk to community rather than.
I'm not familiar with the research you just cited, so I really can't comment on it. I guess I would just come back to what I said in my opening remarks, which is we've been leaning in pretty hard to this issue for a decade, and it's still broken, and we're still losing more people. So we got to think about what the missing pieces of the puzzle are, and we're here to be part of that. We don't pretend to have all the answers, but we want to be part of a well thought out picture that not only protects people who are addicted or mentally ill or struggling with some sort of public health issue, but that also protects the community at large.
I really appreciate that. Thank you. The last thing I'd say is I'm noticing our witness list has no substance use experts, no public health experts, and I'd really love to make sure we hear from them to talk about the addicted brain.
Right. Yeah. And again, understand that that's a critical piece of this, but as we'll be getting into more witnesses, a focus is frankly on how quickly we're processing cases in the criminal justice system. Where a lot of the other witnesses will be addressing that. So Tucker, a very abbreviated piece on repeat offenders, if that's okay.
No, I completely understand, Chair Lalonde. I will just flag it. The second observation I was going to make was that one of the persistent issues that communities are experiencing is repeat criminal behavior that does not necessarily rise to the level of felony crimes of violence, but it persists after apprehension and arraignment and repeats in a pattern, sometimes dozens of times, causing significant harm to communities and in violation of court orders. And that individual does not face a meaningful risk of detention for that behavior until at least their cases are adjudicated 12, 18, 24 months later. So is there policymaker consensus on the nature and scope of that problem? And is the status quo governmental response currently a tenable public policy for you as policymakers? That's the 1 minute version. In this regard, there are real constitutional limitations in Vermont regarding withholding, imposing, and revoking bail. And I just want to flag, as you consider this, to compare it to the differences in some other jurisdictions. And they have different constitutional limitations, different constitutional schemes. But for those policymakers that are particularly interested in how conditions of release are enforced, it's of interest to the public policy discussion regarding how the federal scheme for sanctions for violations of release work. and those are set forth in 18 USC 3148. I find it interesting to compare that federal scheme in that statute with the Vermont constitutional scheme for the standards for imposing, withholding, and revoking bail, including the constitutional limitations on revoking bail that overlay 13 DSA 7575. So that detailed technical conversation for maybe a smaller committee hearings, but it's something that we're focusing in on and trying to, in light of Vermont's constitutional standards for withholding, imposing, and revoking bail, to determine what other constitutionally permissible legal mechanisms exist that can be used to quickly intervene and stop behavior that undermines public safety in a community and ensures compliance with court orders before a criminal adjudication occurs. How do we quickly apply legal pressure for behavioral change to repeat violations of conditions of release? That's something we're exploring and look forward to exploring in more detail with the committees as we go into the session. And I really appreciate everyone's time, and thank you very much for having me in this morning.
Yeah, I appreciate that. And there will obviously be very detailed discussions about the conditions of release and bail issues as well. Did you have a question, Representative Arsenault?
A quick question, just to be sure that we all understand each other. You mentioned the status quo governmental response. Can you just explain what you see as the status quo governmental response?
Yeah, so what it means is what do we do? What's the process when individuals violate conditions of release and engage in additional criminal behavior when they've already been apprehended and arraigned for one offense and they're waiting the disposition of that case? And so that framework that we have in Vermont is constitutionally limited through the mechanisms on bail that I just described. But basically, the result is a violation of a condition of release results in another criminal charge for that violation that's ultimately disposed at the end of the case. So that can be a year later, it can be 18 months later, or 2 years later, whatever that is. And during that pretrial time period, significant harm can occur to the community from individuals who continue to engage in that behavior. And so the question for policymakers is the current status quo response of how we handle violations of conditions of release tenable public policy? Is it working for you and your constituents? Or is some change needed in how we handle that and what the legal mechanisms are to change that in light of the very real constitutional limitations that we have in Vermont?
So to be clear, your description of that, I was asking what exactly you see as the status quo governmental response, and it sounds like you're setting up a scenario where there's a crime that occurs, conditions of release are set, an individual violates those conditions of release and then is cited for criminal violation of conditions of release, and then there's just a long span of time between that charge and adjudication of that charge or any charges that preceded that charge. So is that correct?
Yeah.
Okay.
Great. Thank you very much, Tucker and Commissioner Morrison. And I believe we have Chief Hoag on there we are. Thank you. Did I pronounce that right? Well, identify yourself for the record so I can then find out if I pronounced that right.
You did. My name is Ron Hoag. I'm the Chief of Police with the Essex Police Department.
All right. Please proceed.
So thanks. I'm probably going to cover some of the same material that has already been discussed this morning. I'm going to try to make this brief because I know you have quite a schedule to go through. So in addition to being the chief here in Essex, I'm also the president of the Vermont Association of Chiefs of Police. So I'd like to give you a little bit of the perspective of police officers of Vermont who are working the streets every day and facing a growing crisis in public safety here in Vermont. I don't need to brief you all on the issues. You've already talked about many of those, but I just want to give you an idea of what the average police officer handles in a day. So the typical days are usually characterized by calls of service of two types: citizens experiencing mental health crisis and calls that involve or are the result of the sale and use of illicit drugs, specifically fentanyl and cocaine. And some of those incidents that we deal with are retail theft, and sometimes those are being coordinated by criminal organizations, thefts from vehicles overnight or thefts of the vehicles themselves, burglaries of homes and businesses, addicted persons who might be suffering from mental health issues as well, and causing a disturbance or trespassing. I know that's already been spoken about this morning, or committing other quality of life violations. Assaults and other violence that are related to the drug trade, and unfortunately and too frequently, deaths that are caused by overdose from illicit drugs. So police officers are tasked with listening to those victims, helping the addicted, notifying the families, and bringing those who commit crimes into the justice system. But more and more these days, we hear the voices of victims who are frustrated with the criminal justice system in Vermont. We hear from retail managers who tell us that they won't call us anymore because, quote unquote, nothing will happen. We hear the people who have had their vehicles and home burglarized telling us that they've lost a feeling of security in their lives. We listen to those who are struggling with addiction explain to us how they became dependent on illicit drugs. We also hear from the many that will not go to the commerce centers of Vermont any longer because they don't feel safe after hearing of the escalating personal violence related to the drug trade and mental health. Contemporary policing is about much more than enforcing laws, and many times more about providing a citizen in need with medical care by calling for EMS or connecting the addicted with drug treatment, or providing help to those experiencing mental health issues or homelessness. Officers find themselves functioning as social workers, victim advocates, and mediators in addition to their traditional roles. But nothing is more dreaded by a police officer than notifying someone of the death of their family member. Having done that several times in my career, I can tell you that it's something that I'll never forget doing, and I wish I will never have to do again. The pain that a family member experiences when learning about a person who died of fentanyl overdose is something that no one should have to endure. Unfortunately, as you know, the deaths from fentanyl overdoses continue to increase in Vermont, and we must all work together to stem that tide. Until we decrease the flow of illicit drugs while at the same time reducing demand, we will continue to see that increase. But as Commissioner Morrison talked about this morning already, the overarching theme is accountability. We have to employ demand reduction strategies. That's a given, but there's must be an equal strategy of accountability for those who commit crimes. There's little fear of arrest or consequences by those who sell illicit drugs or continue to commit crimes. Victims of crime feel that even if the culprits are apprehended, there will be no consequence. Or if there is one, it'll be delayed for many months after more crimes are committed. And finally, officers themselves begin to get a sense of futility within our system when their cases are not prosecuted. Defendants are allowed to commit numerous violations of conditions of release and allowed to go free. Police officers join the profession to protect the vulnerable, and when they cannot, they risk becoming demoralized. Law enforcement in Vermont is going to continue doing their jobs to protect us all, but we need your help to do that. So that's what I have. Thank you for listening to me, and I'll answer any questions if you have those.
Appreciate it. Thank you. Questions from either committee? I don't see any right now. I appreciate, oh, yeah, Representative Arsenault.
Thank you so much for being here, Chief. I was just curious if I could ask you a question about something that Commissioner Morrison said, that officers may not take the time to fill out the necessary paperwork because there's a perception that those crimes won't be prosecuted. Does that sound accurate to you?
I think there are cases in Vermont where police officers have become complacent in taking the time to do that paperwork because they feel that the case will not be prosecuted, or their cases in the past haven't been prosecuted for a similar type of crime. Also, it goes back to the cooperation of the people who are reporting the crime, and in many cases, some departments have changed their policies as far as issuing trespass notices. I heard that mentioned earlier about issuing trespass notices because of their manpower staffing. They are asking the individual businesses to issue those and not their officers. That's on a department by department basis, however. So,
thank you for that. And I think we're hearing the word perception quite often, and we're also longing for some more accurate data. So would you say that, or let me ask this question, do you feel that there's communication between departments and, say, Department of Public Safety regarding the accuracy of that perception, that crimes are not being prosecuted?
Well, I know there are discussions that go on all the time between the Department of Public Safety, the state's attorney's offices, and law enforcement. And it's something that we've seen over the last few years where a combination of COVID and other things have caused many cases to not go prosecuted. And certainly with the huge backlog that was in our courts, some of that's explainable. But when we continue to have crimes committed after those initial cases where there are violation of conditions and that type of thing, that's where we're looking to intervene, I believe.
Thank you.
Senator Wachowski.
Thank you. Hi, Chief Hogg. Nice to see you.
Good morning.
Good morning. So I'm wondering, in the instances where officers are making the choice not to complete the necessary paperwork, what accountability there is for them? Because, you know, as I would see it, they should do what they're supposed to do regardless of what others in the system choose to do.
Right. And I don't want to give that impression that officers are simply refusing to help a victim out. That's not what's happening. I think there's conversations that are going on at the time of the incident between the folks who are reporting the crime and the police officers who are on the scene, who are trying to make the best choice for that person at the time. And many of the times that we're seeing now, our business owners simply aren't wanting to give us statements or have that person prosecuted. They're just looking to make sure that person doesn't come back. So they'll ask for a trespass to be issued.
Okay. Thank you.
You all set?
Yeah.
Okay. All right. Thank you very much, Chief. Really appreciate your time and your perspective on this.
Thank you so much. All have a good day.
All right. So we will go to Judge Zone and Terry Carsones. And I don't know, I didn't notice the setup in here where, yeah, I think just sitting at the end there, it's probably absolutely fine.
Okay, oh, great, good. And we had asked whether you might appreciate paper copies, not knowing what might be accessible. So we did send electronically the slides that we'll be referring to, but I have paper too.
Yeah, if you could pass, I know that some of us, including me, like to are old fashioned and still do paper.
Ben, do I have permission to? You're the host, you should be able to. I'm the host? Oh, okay.
You don't have all the power, Judge Zone.
Ready then?
Okay, if you could identify yourselves for the record and then proceed.
Thanks so much. Terry Corsone, State Court Administrator. Senator Sears, Representative Lalonde, committee members, thank you so much for the opportunity for me, Chief Superior Judge Thomas Zone, to participate and give the Judiciary's perspective on this very important topic. Representative Lalonde was kind enough to give us some direction in terms of what topics he thought would be most beneficial to the conversation. So we've geared our remarks to those topics in general. He asked for kind of a brief overview of the court backlog situation currently, as well as measurement tools for backlog in answer to your question, Senator, and also what is currently being done in terms of addressing the backlog in the courts and what our request is in terms of resources vis-a-vis the backlog. So that's what we'll be planning to cover, if that's okay. And did you want us to kind of expedite? I know you said originally half an hour, but do you want us to shorten it a little?
If you're able to, that'd be great. But
I'll try to. But please feel free to interrupt if there's any questions as we go along. I wanted to just at the outset just kind of mention we have a mission statement that the Judiciary does, which is to provide equal access to justice, protect individual rights, resolve legal disputes fairly and timely, and provide everyone the opportunity to have their day in court. And we're going to kind of focus on the timely aspect of the mission, because I think that plays into the whole question about backlogs and whether or not we are able to process cases timely. It is our mission. As was stated about a year ago, when there was a joint meeting of the Senate and House Judiciary Committees, the courts had a backlog before the pandemic. That was certain. I worked in the courts for about 9 years, just before the restructuring happened in 2010. And then after, primarily in the Bennington, Addison, and Rutland areas, but also statewide in a number of respects. And I can attest to the fact that there was a backlog then. And I can also attest that there was a sense of the courts being under-resourced, and that being a reason why day to day there was always a feeling of triage and catching up and not having enough resources to do the work that we would have, liked to do. And certainly the pandemic exacerbated the backlog, which has been referenced a number of times. The biggest reason was the halting of jury trials for over a year due to the isolation distances, the numbers of courthouses that didn't meet the HVAC requirements, safety reasons why those were halted. And that had the biggest impact on the criminal docket, primarily because it's jury draws and jury trials that move cases more than any other single factor. State's attorneys and public defenders will also, I'm sure, have familiarity with an under-resourced kind of concept. And it's not until there's a jury draw that kind of the metal hits the road and the time is to move a case or not at that point. So when you don't have the jury draws or the jury trials, you don't have that incentive. And that resulted in a huge kind of amassing of the criminal cases in particular. To a lesser extent in the civil docket, because civil jury trials were also halted. There aren't nearly as many civil jury trials as criminal. So halting the jury trials was the biggest single factor. In addition, just coincidentally, we were launching the electronic case management, electronic e-filing system in March of 2020, exact time when the pandemic hit. That would have, in and of itself, without a pandemic, had caused some delays because it took time. It took time for court staff, for judges, for litigants, state's attorneys, public defenders, everybody to get used to that new system. From the court's perspective also, they had to scan per unit hundreds, if not thousands of cases in order to get them into the electronic filing system. So there were those delay factors built in for that. In addition, the pivot to remote hearings, again, necessitated by the pandemic because people weren't able to come in person. But that was the biggest silver lining from the court's perspective to the pandemic because we were able to utilize pandemic monies to get the equipment, to install it, and to utilize it. And it has been very beneficial in terms of access to justice, making it much more convenient for certain types of hearings that are appropriate for remote hearings, for people to participate, to connect without having to take time off from work, without having to travel, et cetera. But the remote hearings also took time and was a delay factor because we had to get all the equipment. We had to learn how to use it. There had to be training, like you all in the State House. It took some time to get used to that system, and that was a delaying factor as well. I mentioned the HVAC. A number of our older courthouses just didn't have the air quality system to be able to function safely, and as a result, we weren't able to schedule nearly as many hearings at that time. And lastly, a factor that impacted everybody was workforce levels. We had a lot more people leave for all the different reasons. People who had kids at home going, to school remotely, they had to be there. People who had health reasons, or people who were nearing retirement and thought, well, this might be a good time, especially, we're starting e-filing. Maybe I'll retire now. So there was a lot of workforce attrition, and that meant more time recruiting, training, et cetera. So that whole variety of factors kind of resulted in what we're talking about as the exacerbation of the backlog numbers. And in answer to your question about how we're making progress on the backlog. So there are different measurement tools, and we have here 3 of them, the primary ones that we look at. It's kind of a combination of them. I don't think there isn't any hard and fast backlog measurement that we can say. But what we'll try to explain is that we are making progress. Slow progress, and probably slower than we were certainly hoping last year, mainly because of the 5 judicial vacancies that we had for many months. Because you need a judge to make cases, to issue orders, to dispose of the case. So the fact that we had 5 vacancies during a time when we were really hoping to be able to point to great progress in the backlogs, because now we do have e-filing in place, we do have remote hearings in place. We do have the advantages that resulted from the pandemic. Our cards and votes are fully open.
Yeah, question for.
Yeah, just with the 5 vacancies, can you remind us how long that was? Because I know that names were put out, but, so there was an opportunity, but they weren't appointed. What was the timing on that?
Yeah, it varied because the 5 retired at different times. But in general, if somebody retires, the Judicial Nominating Board is notified. There's an application period, then there's an interview period, a vetting period. The names are then sent to the governor. And then it can vary very much in terms of how much time that it takes for the governor to appoint. So for the course of the year, for the 5 vacancies, each was at least several months, one was as long as a year.
There was a number of names were sent to the governor, I believe, in December. We had 2 judges retire at the end of the year. There was also another position that was open at that time. So we had 3 judges who were appointed and went through confirmation during the legislative session. So that was from that gap. The judges retired in December. We had additional positions that were open. We then had a judge who did not seek retention. He stayed on, but then that was a vacancy. We then had another judge retire in October. We had a magistrate retire in the summer. So it was all.
They're in addition to the 5.
Yes, taking place at different times.
So it's unusual to have that many vacant at the same time. And that doesn't mean that there's just 5 dockets that are impacted by it. It's the other dockets where those judges are then trying to fill in. And there's no way, I mean, it's like a master chess player trying to not jeopardize the dockets at any particular county, but having to constantly move. So those judges who are filling in their dockets aren't able to be as scheduled as fully as possible. So, but the measurements that we have that we look at is just one is number of pending cases. How many pending cases are there? And we have a chart here that just kind of gives you an example of pre-pandemic 2019 cases filed in the beginning and then where the cases pending at the end. You can see in most dockets, it's it can be half. I mean, normally that would be kind of what the usual ratio would be. You'll see fiscal year 2023, it's the reverse. In the criminal docket in particular, and these are felonies and misdemeanors, there were 12,512 cases, misdemeanor and felony cases filed statewide, cases pending at the end of the year, 15,000. So, I mean, you'd want it to go down. It went up because you had that big bump of cases that were in addition to the new cases filed in 2023. Judge Zoning actually ran some numbers when you asked your question because we thought, well, this may not give as good a clear answer to that. Are we making progress?
So if you look at the chart, the cases pending end fiscal year 2023 for criminal, the number is 15,227. That same number at the end of fiscal year 22 would have been 16,692. So we're actually 1,465 in a reduction. The civil number went, we show here as 4976 in fiscal year 23. In 22 it was 5556, a reduction of 580. The family domestic number was 2764 at fiscal year 22, and then you'll see it's 2357 here for a reduction of 407. The juvenile number that we show here is 1597. At the end of fiscal year 22, it was 1464. That was an increase of 133. And we'll talk about that in a few minutes about what our needs are and what our plans are to try to address that, to be responsive to that type of growth.
In the, Judge Zoning will be getting into kind of what steps are being taken to address it, but it's been an all hands on deck approach in terms of each unit and statewide having backlog plans. What would be the best way to move cases in this docket? Let's look at the scheduling. Let's look at our resources. Let's review all the older cases, get the ones in there. All kinds of strategies have been employed. And the fact that we've made this progress again, slower progress than we would have liked, but in the face of that many vacancies, I think it just speaks to how hard judges and court staff are working to try to address these numbers that they know are of concern, and not satisfying our timely aspect of our mission.
Just a question over here, or a comment.
The perception that the Commissioner of Public Safety, Chief of Police, others have, and my constituents have, is that it's the repeat violation of conditions of release that aren't dealt with that is causing a lot of the complaints, consternation, whatever you want to call it. How does that relate to the backlog? I mean, somebody has 40, Bennington, this is an odd number, 47 violations of conditions of release, including new crimes, and it's finally dealt with. That's what has, to me, I'm trying to understand how the backlog and who's accountable. So in Massachusetts, the parole, I think probation is actually responsible for those on conditions of release. In Vermont, nobody's responsible that I can tell. No agency, no governmental group is responsible. Police or state's attorney gets somebody in and they file charges and it takes months to get through. This is where the perception, I think, problem. I'd like to understand how the backlog keeps that person who can accumulate 47 violations before he finally is placed at Marble Valley. I believe that, we could have dealt with that after the second violation and probably found an alternative to Marble Valley. I don't know, but just thinking off the top of my head, probably were alternatives. Included in those violations were new crimes. Also included was failure to go to competency evaluations, you name it, failure to appear in court. No, I'm trying to understand how that all fits in with this backlog.
Judge, can you answer this question about who has responsibility?
Well, as you know, Senator, we were talking a few days ago in Senate Judiciary about the issue of what happens in some states when someone is released pre-trial. I believe Illinois was referenced as a state that has, they have it actually two ways. About 3/4 of the counties in Illinois have a pretrial monitoring system that is operated by the court administrator's office for the state. Some of the larger counties, like Cook, Lake, and others, actually have their own pretrial monitoring system, and they don't rely on the state system to monitor. Massachusetts, the federal system, a number of states have pretrial monitors. Vermont does not have that. And so when someone is issued conditions of release, there is no one that goes out and checks. Now, in some counties, I am aware that law enforcement will go out and do compliance checks, and they would report to the state's attorney. If someone has a curfew, they may stop by, or they may do things like that to try to instill a recognition in the defendants that there is responsibility and there is accountability. But beyond that, we don't have any specific entity charged with enforcing those conditions.
So how does the backlog contribute to the length of time it took to get this, that's the 35 to 40-year-old before the judge finally got fed up? Well,
you mentioned a couple of things. You mentioned that there's original charges, that there are additional charges ongoing, and you also mentioned competency. So competency will oftentimes, as we've seen over the past few years, add delays. And when the court is, when you look at our 15,227 cases, a number of those cases, and Chair Lalonde talked about this with appropriations in his presentation, a number of those cases are over 2 years old, over a year old. So our backlog of looking at those old cases, many of which are serious cases. You can have sexual assault. You can have sex offenses involving minors, aggravated assaults. And so what the courts have to do is try to focus on, we need to take care of these cases. We need these 2-year-old, 3-year-old cases, 4-year-old cases. We have to process those. And so when you're focusing on trying to bring those cases forward and you have someone who violates conditions of release, well, do you say, okay, we're going to put that to the very front of the line or not? And frankly, it's a balance. It's sometimes the answer to that question will be yes, depending on the specific facts and circumstances. And sometimes you have to balance things. For instance, When a judge has a case, we'll use a domestic assault, a misdemeanor domestic assault that may be 2 to 3 years old. That is a part of our backlog. And that case is scheduled for trial. The county may have 4 trial days ready. And someone is held without bail under 7553A, which means they're entitled to have a trial within 60 days. And they have to have that trial. And then we have an individual who has repeated violations of, let's say, misdemeanor violations of conditions of release. And the state's attorney saying, well, we need to do something here. So we go to jury draw. We have 4 trial days. We have a case that is going to take, let's say, 3 days, maybe 4 days for the 7553A that we have to try. We have the 2-year-old case for the domestic assault with the victim who is waiting for the defendant to find out what's happening and how that case is going to go forward. And we have these repeated violations. And so I'll ask everyone around the table, who goes first? And I say that because the reality is that is what we're doing in each of our 14 counties each month. And that's a balance to try to say, how do we address the backlog and move cases? How do we address the instant cases that need that attention? And should I jump ahead?
Sure, because it speaks to his.
I'll just jump right into it then, Senator, if it's okay. Steps to address the backlog, because the dilemma that you have identified is precisely what we've been addressing. And I would say very quickly that we are not writing on a blank slate when we take steps to try to identify a backlog and try to identify what are the best steps to take for case flow management. Whether it's the Bureau of Judicial Assistance, the National Center for State Courts, National Judicial College, there are legions of entities that have addressed these issues. They have identified necessary factors that we need to have, necessary components to address backlogs and case flow. And they include input from stakeholders. And we do that. We seek input in these types of cases. That example I just gave, we would look at, I see Ward Goodenough here, the Windsor County State's Attorney. If this was Windsor County, you would say, Mr. Goodenough, which case do we want to go first? Or from the state's perspective, what do you think? We ask Defense Counsel what's going. We look at the schedule. We see what we can get in. When we're developing strategies on bringing cases.
I want to just say I very much appreciate the response. Our problem is both actual, the rise of criminal activity due to drug involvement, continued domestic violence as a major Vermont crime. This is my views. And the perception that Vermont is soft on crime because we read the headlines of the 47 violations and nothing happens. So I do appreciate that over the years, I've worked with the Judiciary, both Judiciary Committee and Appropriations. And it is frustrating, I know. You put in a budget with the governor. The governor agrees with some of it, not all of it. Then you go to the House, they usually agree with a little bit, not much. And you go to the Senate, and they give you whatever you need. No, in all seriousness, we try to go a little higher than the House. And then it gets into conference and it all meets in the middle. But that's the reality of your situation in terms of resources. But I appreciate hearing about the difficulty for state's attorneys, defense attorneys, everybody to decide what takes priority in the court. I appreciate the answers.
And as the slide indicates, there's a number of things we've done, but I would highlight that when we talk about priority scheduling, what does that mean? Well, it means that when we have that case of someone who continues to violate conditions, that case, we need to have the judges, and we've talked about this, we have meetings with the judges, and I have highlighted this during trainings, that we need to go and make sure that if there's a way to get those cases, you get if someone's continuing to violate conditions, we need to be looking at that driving case, the first case, and say, put it on for trial. Because what do we know? We know that in 2023, there was over 15,000 cases, or 14,500 something cases, I think, that were resolved by plea or dismissal. and there were 60 jury trials in the criminal docket. And we also know that the vast majority of those resolve when there is the certainty of trial, when we were right up on the trial. And that is 99.59%. The year before, it was 99.68%. So there's a consistency here. But what we need to do is start moving those cases to put them in a position where we can try them. How do we have the ability to try them? Utilization of retired judges when available to come in this past year. We have judges, as we've heard, who have just been appointed and sworn in. They will be starting this month. It is my expectation that you will see results from that. We have extra judge time that we're devoting in the counties. I've spoken to the judges in the affected counties. Windham County, Judge Treadwell is adding numerous additional trial days. We're adding trial days in Rutland, and we're trying to add additional days in Bennington. We are adding additional days in Addison. We are adding additional days in the Northeast Kingdom. We are having judges who now have the ability to focus on addressing the backlog by scheduling the trials and having those cases move forward in a way that we couldn't do before. We didn't have the resources. And when we look at going forward, as we said, the challenges we encountered were the judicial vacancies and the staffing.
So before you move, Senator Vahouse.
Yeah, no, I want to be very clear that my question was not a reflection on the hard work that you're doing. I know that you're working incredibly hard. I just wanted to make sure that when it was sort of characterized that the backlog was solved and things hadn't improved, that the backlog in fact had been solved and we weren't relying on perceptions and sort of outliers to drive things. So I do want to be very clear. I was not.
It wasn't taken.
Okay.
And we think it's a very logical question too. The other kind of measurement tools, I guess, that we look at is there's something called disposition guidelines, which is based on kind of a national standard in terms of how long it should take for cases to resolve. There's a chart there just showing also in terms of the cases that are over disposition and under disposition. So it gives you the percentage for each docket too. I mean, the goal, they're aspirational, but like that's been pointed out several times, there's always complexities that kind of enter into it, but it's a broad measurement tool. And the last measurement tool is clearance rates. Again, if you can dispose of at least as many cases as come in during the period of time, you have 100% clearance rate, and you're never going to make an inroad on the backlog unless you at least have that. So we strive for greater than 100%. So it just kind of gives you in the last year from today back what the clearance rates are now. So you can see that, I mean, we're making slow but some progress, and we're really hoping to be able to make more progress. The more progress.
I did have a quick follow-up, and that is around looking at nonviolent cases that are 2+ years old, and if there's an openness to just dismissing those cases. And if so, if you have a sense of what number of cases that would be.
It depends on on what categories of cases you're looking at, but there's a separation of powers issue that the determination of what charges to bring and what to prosecute falls on the executive.
So I should ask them that question, not you. Okay.
Vermont does have a rule of criminal procedure 48 that there is a limited ability of a judge making certain factors to dismiss cases in the interest of justice. But that's a case specific. That's not a global. There was one county, Senator Norris up in Franklin County. They went and several years ago, Judge Maley, prior to his retirement, there was, I believe, was over 400 cases that were dismissed based upon the court and the state's attorney and defense, I believe, all getting together and doing that. But it is not something that the court can just say, well, we believe we want to get rid of this category of cases. That's
Got it. Yeah, it just seems like in those instances of like nonviolent misdemeanors, if they've been out on conditions of release for 2 years, they've served their time, essentially, like likely they would have been sentenced to less. So I guess my question for you, and maybe you don't have the answer, but is the sort of second half of that. Not would you do it, but do you have a sense of what number of cases that would be or that we're talking about?
I could get you that.
Okay, that'd be great. Thanks.
We have data that we can generate for the age of cases and then try to dive down within that as to the type.
Awesome. Thank you. That would be great.
So Senator Hashim, and on the appropriations website, Senator Wachowski, is information I provided when I presented to the Appropriations Committee that does have a document that shows ages of cases on a county by county basis. It's something that you might be interested in looking at. Senator Hashim.
Thank you. So since I was in the House and now in the Senate, what I've heard often is how each county has its own little criminal justice system. And so one of the questions that I have is regarding the geographic differences between the different counties, and specifically to something you had mentioned earlier regarding prosecutorial discretion. Is there any sort of, are there any sort of changes that you think that would increase a sense of uniformity between the different counties and have just a more streamlined system when it comes to deciding what cases go first?
I would not want to venture into the realm of prosecutorial discretion in the county.
Fair enough.
I'll let them discuss that.
I'll leave that question. Thank you.
I guess just as a follow-up, and I think you were starting to get into some of the things that the courts are doing, but looking at best practices across the 14 courthouses, setting aside what the prosecutors are doing. And if you could just hit on that a little bit, but I know we're kind of running out of time, and if you could just jump to judiciary needs, but if you could just hit at a high level, as far as what you're doing to try to implement best practices across all 14.
As resources from the national, as I said, the National Center for State Courts, National Judicial College, and other entities that talk, other organizations that have studied this issue and looked at what are the things we should be doing. We have conducted trainings with the judges as far as case flow management and to address case flow. We are going to have trainings that also with staff on case flow management as part of their staff training days. And what we're doing is taking what we learned, experiences from a national level as to what works, and trying to bring them and implement them in Vermont. Likewise, if we see something that's working in County A, we're going to try and implement it in County B. And so we use the term best practices. Well, the best practices in some areas depend on what county you're in. Because as Senator Sears led off today, the resources that we have to utilize don't let us have one size fits all for 14 counties. We have to be able to address the issues with what we're handed in each county. There may be a different resolution in Essex County than Bennington or Chittenden County based upon resources available to that case. And so the best practices, we'll be looking at whether it's mental health, substance abuse, how to address recidivism. We're bringing in the strategies that are employed in other jurisdictions and again, across our state to try to utilize them. And I think I've said this before, we have regular meetings with the judges when information comes up and when there are concerns and areas raised that we might want to look at. I take that and look at it, and we talk to judges about areas that we might be able to improve upon or make better headway on the backlog with.
Thank you.
And a year ago when we met, we had a statewide backlog plan that we'd asked each unit then to tailor to its particular needs and cultures and resources. And each unit has now a backlog plan that incorporates those best practices, whether it has to do with scheduling, whether it has to do with data cleanup, whether it has to do with a regular review of the oldest cases to see what can we do so that the whole goal is to waste as little hearing time as possible and to make sure that every hearing is dedicated to moving that case forward. No kind of lag time. Cut down on the status conferences. Reduce the numbers of motions to continue, just to avoid any kind of wastage of kind of the very precious hearing time that's needed in order to move these cases, either for the judge to make a decision or for the parties to reach a result that they then, submit to the court.
Great, thank you. Representative Dolan, then Representative Rachelson.
Just seeing that you put the judiciary needs slide up.
We wanted that to sink in.
Yes. Well, and so I'm curious if you can give context too. Are these pieces, I appreciate you bringing it to us, were these also put to the governor to be in the budget as well?
Yes, this is the fiscal year 25. Oh, well, I should speak actually. there were 2 positions that were in the fiscal year 25. It's very recently evolved to 3. And Judge Stoney, did you want to explain each of those now? We can explain why it's moved to 3.
The first position we were looking at is a northern float. We've heard quite a bit about Chittenden County and the needs that Chittenden has that are unique. And so if someone right now, we are in need of additional judicial resources in Chittenden for criminal, family, and even civil for that matter. And the idea is we have one more judge. That judge could be in the northern area. They can help in Chittenden. They also could help in Franklin and even come down to Addison and Washington to address those counties to respond to the needs and to be utilized in a strategic way. It's not just you're in one courthouse forever and always. It's okay, here's where we need you, and to try to do that. We also have had a number of questions from different counties about treatment court. And the idea of having a single treatment court judge is something that we think would be beneficial. We have the ability to have a judge, given our current number of treatment courts and the schedules and the locations, we think that if we had one judge who was dedicated to doing treatment court, it would let that judge be immersed in that docket. That judge would be, I'll use the word champion, of the treatment courts. So the other counties, I know Windham County is interested in implementing a treatment court, and there's other counties we're hearing from. That judge would also be able to serve as the resource to assist other counties in potentially looking at implementing treatment courts if it's something that those communities want. And so we think that having one judge there is beneficial. What else it does? Oh, I'm sorry.
Go ahead. You were just going to say, okay.
We think about it. What else it does is right now, the judge who's in treatment court has to leave their normal docket. And so it's not something where they're just have this available time and, oh, let's try treatment court. I'm either in, let's say, Chittenden criminal today, or I'm in treatment court, or I'm in Rutland criminal or treatment court. And so it allows the judges who would otherwise be devoting their time to treatment court, in addition to their regular docket, to focus on their regular docket, thereby assisting us in moving the cases and the backlog. And the final one we were and I would note, we also made a request. When you talk about best practices, Chair Lalonde, we made a request to the opioid settlement, to try to get money for training. Because what we want to do is, even if we don't have treatment courts in all the counties, the citizens of those counties should have judges who are highly trained in the treatment court strategies and techniques that work. Because just because you don't have a treatment court doesn't mean there aren't things you can learn to benefit your docket. And I would note, it doesn't mean the judges aren't skilled. And I've compared it to a doctor. You might go to a doctor who's your general practitioner, and he might be able to do surgery on you. You'd probably want to go to somebody who's had a few more courses on surgery before you let them do it. And what I'm saying is this enables all the judges to have those extra training to benefit them and thereby benefit the court system in the state of Vermont. And finally, we were looking at a third judge for the statewide juvenile docket. This was not something we had originally come up with. We had what's called a master. A master is a position that was put in a few years ago. It's a limited jurisdiction. The master helps in the Chins cases, but they don't have the full authority of a superior court judge. And we found it beneficial. But again, they can't hear all the cases in the docket, and they can't hear criminal or health in the other docket. Rachel Malone was the master. She was appointed to be a superior court judge. The master position sunsets in July of 25. And so the question for the judiciary was, do we want to hire a new master who is limited in their authority, or do we think it's beneficial where we are now to have a judge, someone who has full authority?
Who can be dedicated to the juvenile docket and target those cases around the state. You have a TPR case that needs to be heard. No time on the dockets, no judge available. So that's the reasoning and why it kind of came up, because we didn't know until she was appointed that there was this position that we thought could be utilized. And we're hoping that the monies that would be allocable to it through the original funding could help offset the cost of a new judge, at least until the end of that time. But it would be, we feel, just much more beneficial to the system as a whole and to the juvenile docket in particular, to be able to have a position dedicated to being assigned to help where needed around the state So that's the third, and why it wasn't part of the fiscal year 25, because we didn't know she was going to be appointed and that we'd have this opportunity. So that's why.
So before we get into the judicial assistants, Representative Rachelson, then Senator Bahowski, then Senator Hashim.
So it would just be good for us all to know how many judicial vacancies are there right now that we're waiting on to be filled?
Two.
Okay,
The governor has the names that were submitted to him for a Superior Court position.
in December.
From Judge Carlson's retirement. And he has the position for a magistrate position in the southern part of the state for the retirement of Magistrate Hoyt.
So having those vacancies filled soon would help, and they're already in the budget.
Correct.
So that's just a low-hanging fruit, so to speak, if we can encourage the governor to fill them quickly. Because I know we sent up.
And if I could note, these positions would not be advertised for saying that we're hiring someone to be a treatment court judge. What would happen is, each year, the chief superior judge comes up with the judicial assignments. This would allow him to have a rotation line item for assigning a judge, whoever it may be, to one of those positions. So we wouldn't be hiring someone to be a juvenile judge or a treatment court judge. We'd be hiring a new superior court judge. We would then have the flexibility for new assignment slots that do not currently exist.
Great. Senator Bahowski?
Yeah, so my question is around treatment court and how many counties don't have that service? Do you know off the top of your head which counties have treatment court and which ones do not?
We have a DUI court in White River. We have 5 counties with treatment courts. I can say where they all are, but
That's fine.
But so 9 counties don't. There are some counties who have the ability to go to the other counties for treatment court, but that's not everywhere.
Okay, and whose decision is it to have treatment court or not have treatment court or send someone to another county or not?
The treatment court is something that the local community supports and makes a proposal. That proposal comes to the court administrator, the chief superior judge, and then the Supreme Court decides whether to do it. But it falls on state's attorneys. It falls on the defense bar and the local service providers as to whether they want such a court and whether they can support the court.
Okay, thank you. That's really helpful. And I certainly think the idea of a statewide sort of treatment court float makes a lot of sense, but I would want to make sure that funding for training those judges really well in substance use was available to you before we started dropping someone in there who maybe didn't have as much training in that system.
No, when I do judicial assignments, we try to maximize the skill level of the judge with their particular docket. And I can tell you that with respect to treatment court, whoever would be assigned to the first, I'll say the inaugural treatment court and thereafter, will be someone who has had significant training and experience as of even today.
Amazing. Thank you.
So we have Senator Hashim, Representative Andriano, and then Senator Norris.
Thank you. So, question about treatment docket. We've previously heard about about harm reduction, but also we've heard about the lack of accountability or the perceived lack of accountability. Do you have thoughts on how a treatment docket addresses both providing treatment but also creating a sense of supervision and accountability? Do you have any thoughts on that?
I think that it is a level of supervision and accountability that you would not get in the normal docket nor in a normal probation supervision. You're coming in every other week, you're meeting with providers. It is intensive. And as far as the treatment, you need treatment, they're going to get it for you because that's what the treatment team is there for, to work with you to assure that you have treatment when you need it. And so those type of wraparound services don't exist outside of that. So it provides what would be ideal for every citizen of Vermont who comes into the justice system to make sure that, yep, they're going to be seen all the time. They're going to get all the treatment that is necessary. And there's a team of individuals there to assist them to help pick them up and move them forward.
Thank you. And the other question, so currently treatment dockets are federally funded through a grant. Is that right? So if this were to turn into a statewide treatment system, what would the funding mechanism be like, or would it change or not change?
I'll let Terry address the funding side.
Well, I mean, it would have to come from, general fund, same way, have to be added to, I guess, the judiciary budget. If it would come. Right now, it's strictly federal. And it has been, I think Rutland's the longest, is it 20 years now? And there's been, continued success in terms of that funding.
And thank you. So my follow-up to that is, so the current treatment dockets are federally funded, and there are certain rules and policies that we have to follow that accompany those grants. And so if this were to be statewide coming from the general fund, we would have more authority as to how we shape policy, or rather the judiciary would have more authority on how you shape policy for what the treatment docket looks like.
Yeah, I don't believe the grants in any way fund the judges who are utilized in the treatment. Yeah, I mean, they fund the treatment court coordinators, for example, and I think some of the staff otherwise. But the judge who's been plucked from his or her regular docket to cover treatment court, that's always just been from regular funding, general funding for those judges' positions.
There may be some restrictions on the grants with the type of individual cases that can be brought into treatment court. There may also be other types of restrictions there. So yes, if it was general fund, we in the state of Vermont would get to decide what it looks like. But most of the restrictions, as I understand it, most of the guidelines are really for best practices. And we'd be following those anyway. We've developed protocols and best practices and statewide policies for our treatment courts to follow, to conform to that. So there would be some shifts, but I don't know that it would be something that significant.
Okay, thank you.
Representative Andriano.
Thank you so much, Chair Lalonde. Thank you, Judge Jone and Terry. I'm going to leave my camera off because my photo is more attractive than I am at the moment. In listening to your testimony and hearing testimony from you, over the course of the past several days we've been in session, and also last year, it really seems to me that you are doing everything you can in order to address this. You are pulling all the legal levers available to you, which sort of leads me to wonder, and to begin thinking about, what sort of outside the box ideas might there be in order to address this. And a few moments ago, you were talking about, things like masters and things like that. And so I'm wondering, is there any ability to use something like masters or some other way of trying to dispose perhaps of these lower level cases that wouldn't have to involve judges? Or is that something like that just impossible? I guess another way of putting it, is there a way of sort of expanding that aspect of it, which perhaps may be easier or not? I don't know. I'm just sort of throwing out a question here. Rather than having to go through this really, really, really rigorous judge process just to get more people in order to begin processing particularly these low-level offenses.
Could be done. I'm sure we could. I wouldn't recommend it. I am a believer that if we're going to have judicial officers, we should have full-time judicial officers who are able to address all the cases and be there to assist in all the matters, as opposed to someone who is of a limited authority as a master.
I will mention in terms of Representative thinking outside the box, when I mentioned all hands on deck, one way that we did try to, again, fully utilize as much as we could, or a number of probate judges, for example, were especially assigned to hear RFA cases, to hear small claims cases when we had the judge vacancies, as a way to try to make sure those dockets didn't languish. And it was using, again, through their largesse, but they were willing to be specially assigned to cover those kinds of cases. So we do try to utilize, whatever kind of resources available, but we appreciate the suggestion and are kind of always kind of on the lookout for what might work. We have a network with our New England counterparts, and finding out, what they're doing that might be helpful. And I know that they've used, and we've used in the past, volunteer attorneys who act as acting judges. So that's another kind of, who serve as acting judges. That's another kind of potential possibility along the lines of what you're suggesting.
And when you talk about outside the box, oftentimes walking the halls of legislators, or even in committees will say, hey, have you thought about this or that? The answer is sometimes and sometimes not. So please, if you have any ideas, and if you may think, well, this is just a crazy idea. You don't know. It may lead to something. And so we continually try to look and see what's working, or to expand things. And actually something came up, and I won't get into it today, but someone did that a couple of days ago, and I went, that might be a good idea. We're going to look at that. So it does work.
Right, so we have Senator Norris, and after that, if you could hit on the 10 judicial assistants very quickly. And once again, we're falling further behind, but that's fine. This is all good conversation. I do recall last year when we had this similar session, I guess everybody was just getting ready, but I don't recall there being as much questioning, but this is great. This is actually great. So Senator Norris.
Yes, Judge Zoni, and this may lead right into the judiciary needs. I guess my question is twofold. What operational changes have you been looking at as we move forward with these new positions? Because it's, I believe, over the past 4 years, you've asked and received additional monies for the judiciary. So in my mind, I guess if nothing changes, nothing's going to change. So are we looking at the possibilities of, night courts, weekends, extended hours? And the second part of my question is, as we obviously look at the needed necessities here for the judiciary, and we take care of the judiciary, and this may not be a question for you, what effect is this going to have on the Defender General's office or the state's attorney's office as far as the needs they may need also to address increased use of positions within the judiciary?
I think that when we're looking at going forward, we have to have the approach of considering everything. And you mentioned night court. That's been brought up, and I can think of benefits to that. I can also think of impediments to that. We're having enough difficulty right now finding security for the daytime. Are we going to be able to find adequate security for night? What about staffing? Are there contractual issues with our staff, Defender General, State's Attorney, or other entities that would prevent attorneys from having to work day and night? And so there's a lot of complex issues that come into that. And that's something that the stakeholders would have to get together, I think, and discuss and say, is this something that we could look at? So I don't know that that's something that would work in Vermont, given our current situation, but it's not, doesn't mean we can't talk about it. And as far as the second half of your question?
Well, I mean, it's kind of a trickle down effect here. I mean, if we get the judges, state's attorneys, and Defender General's office.
The answer is yes. There is a trickle down effect. If we get more resources, and right now we're asking the attorneys to do more. There will be more trials coming up in the state of Vermont. That will be adding pressure to the defense bar and the prosecutors. That's necessary to move the case. And we're going to continue to do that. So when the state attorneys come in and say they need additional resources, the Defender General says it, we agree. We are a judicial system, and every part of that system to function properly needs to be adequately resourced. We're trying to do remote hearings. That's something which has been an impediment to us moving forward at different times. And you have Commissioner Demo who will talk about the stresses and the issues that the Department of Correction has. And yet we're asking them to help us with remote hearings and have staff do that. We support them getting additional staff to be able to help with the remote hearings, because remote hearings are something that will help us address the backlog and provide justice to the individuals who are currently held.
So as the old saying goes, the buck may not necessarily stop here.
The buck stops here and there and there. It's with all of us in our stakeholders.
Thank you.
So if you, Representative Goldstein.
So thank you. So much has been said about the lapse in filling the 5 vacancies for judges, right? Also, as being a member of the Judicial Nominating Board, I think there's 3 of us that were left from that didn't time out or whatever it's called. And I keep hearing the governor and the administration basically get hit on pretty hard that they didn't act fast enough. I don't really think that's fair. I don't think anybody can plan that 5 judges are going to get done all at once. But in saying that, and about how far we got behind in those 5 areas that those judges did retire, how did we do in the other areas? Did we Did we stay the same? Did we get ahead? Did we fall further behind?
Well, we did very well, because as our slide on the clearance rate shows, throughout the state of Vermont during last year, domestic was the only one that wasn't over 100% or higher. So even though we had judges from Franklin County who were coming down to work in Rutland, pulling judges from Windsor County over, we have magistrates coming from the northern part of the state down to Windham County. We had judges going from Windham County up to Caledonia County. We had judges moving all over the place handling 2 dockets, and they have been able, through their hard work and dedication and working with the staff and the attorneys, who also were very helpful with us, to make sure that our numbers were still above 100%. And so we didn't lose ground. We gained ground. We just didn't gain as much as we need to gain.
And I applaud that for happening. I believe that's, you did a fantastic job on that. The other thing is we just got done meeting on the last judges, I think December 18th, right? So there's not a lot of time in there with everything else going on, holidays and all that stuff. But, I think in 5 years that I think I've been on the JMB, I just, it's amazing to me how many judges have retired or moved on or decided they don't want to do it anymore. I don't know how we fix that situation either. But regardless, no matter what, the amount of dockets that are going up to you and all this stuff, it's like somehow, some way, things, and I know the questions have been asked, but there's more of them that's coming. We have an underlying problem that still is not being addressed. I have yet to figure out what that is. Maybe I'll catch you in the hallway sometime and we'll have a good question on that, an answer. Thanks.
So.
Oh, I'm sorry, just wanted to say, we didn't mean to at all fault the governor. We just wanted to say that was a reason. To have 5 vacancies at once is unusual, and to try to then juggle judges to fill in was one of the reasons why we weren't able to make as much progress as we would have liked. So I didn't mean at all. And I wanted to explain that there's a lot of time, the time frame doesn't even involve the governor. It's the, application process. It's all the vetting, so I'm sorry if I gave that impression.
Wasn't it all pointing at you? It's constantly said all the time. It's just more what I feel unnecessary bashing. And we're all in this together. Sometimes people go and they get all tied up in this one thing. They want to blame the blame game. And, I'm sitting in this chair and we'll take my fair share of blame and maybe some extra.
Well, but now there's so much unbelievable time involved with that. It's an important process. And so. Anyway,
yes, there is.
A reality versus anything to.
It's nothing to do.
Okay.
Do not take that personally. Thank you.
So Senator Sears, and then we'll have a last question from Representative Shaven.
Just want to suggest on the judicial masters issue, you have a conversation with Representative Squirrel and myself maybe at the same time, because I kind of remember that as a special grant type of event. And it was a tough sell, and your predecessor sold it. And if we're going to undo it, then there will be a lot of questions. So it'd be helpful for in terms of appropriations if you met with both of us on that.
Oh, that'd be
great. Great. Representative Chase.
Thank you so much for all of this information. These clearance rates seem to be the most helpful data on progress related to the backlog. And when I look at that, it seems, certainly progress, but not nearly as much as we'd like to see and need for our communities to be having the results we need related to public safety. So I'm just curious if you have a sense of what the clearance rates sort of need to be over the next 5. I mean, I don't even know what the goal is. Is the goal to get to a certain level with backlog or no backlog in 5 years, in 10 years? And do those rates need to be 120, 130%? What are we looking at?
The rates definitely need to be more along those range if we want to dig into the backlog, just because of this big bubble that built up. I mean, if we hadn't had the pandemic, these rates would be, I think, perfectly, fine. Although again, lower because of having to fill in as much as we did this past year. But in order to address the backlog, I mean, I don't know that there's a mathematical formula, but certainly it'd have to be more like 120, 100, 50 to really make the inroads, which is why we're asking for the additional resources. And I guess just very briefly, in terms of the judicial assistance, actually Senator Brock asked for what would be needed to get kind of like the of staffing levels around the state to have kind of an equitable distribution. I looked at when I first came in a year ago, what's kind of the plan. I mean, having worked in court as court staff, just kind of knowing you're always feeling like overwhelmed and never having enough and wanting to do something about that. We looked at the numbers, and similar to what they do at state attorneys and public defenders, okay, how many cases per staff member are there? And then looking at that statewide and seeing that there were inequities among the different counties, some of which I would say and have said, we're okay, we're holding our own, we're okay. Others drowning. So trying to shore up those numbers and then looking at that calculation resulted in the 10 judicial assistants in terms of, in response to Senator Brock's question, what would be needed to have just a bare minimum of coverage.
Yeah, I guess I'm just not shooting for bare minimum of coverage. I'm shooting for reducing and clearing out the backlog in some reasonable period of time, which I haven't heard anybody really specify what they think that is. So, I do think it's actually pretty straightforward algebra to use this data to figure out if we wanted to clear the backlog in 5 or 10 years, what do these numbers need to be? So I would love to maybe see if we could get there at some point this session.
I have to do math.
I'm happy to help.
No, I agree.
It's a strength.
And I just would rather, in all honesty, knowing that permanent positions are very precious, rather say, instead of saying, oh, give us 50, no, let us be fair on our best estimates, because there are counties where they say, feel like we're okay. So if we try to achieve that level in all the counties and see how is that working, we'd rather do that than kind of overreach or over ask.
Yeah, and I'm not saying your ask isn't reasonable. I'm saying from our job is to decide what we also think is reasonable. And so I don't quite have the data yet. I'd love to be able to talk about what I just spoke about.
Okay.
And I would be remiss as co-host if I didn't say that it looks like Representative Oliver's hand is up.
Yes, I was just going to say I lied about Representative in the last question. So Representative Oliver, I don't actually get to see that Representative Oliver had his hand up, but he texted me. So go ahead, Representative Oliver.
Thank you. Can everyone hear me okay?
Yes.
All right. Thank you, Chair. Good morning, Judge. How are you?
Good morning.
My first question, I guess, will be pretty brief. It has to do with the slide you have up, but I'm just looking for a little more information on it. Comparing prior to the pandemic and now, actual numbers of case clearance, say 2017, 2018, or something like that, compared to what we're dealing with now. What are the actual numbers? If that's something you have, maybe I missed it.
Yeah. I don't have that number as far as 2017, 2018 for the clearance rates. This type of data we've been focusing on a lot more in the past couple of years.
I know it's not apples to apples. I guess that's just for my own curiosity. And the other thing I'm wondering about is what we're dealing with is this crime thing where we started out talking about with law enforcement and the continual recidivism or lack of curtailing the behavior. And I'm just wondering, from what I see in court, the number of failures to appear has been increasing dramatically. It used to be, you had 80, 90+% of your people show up just for an arraignment day. And now you have 80, 90% that don't show up. And so these folks are still out there reoffending. They get brought in on a warrant. They don't show up. They go back out and do it again. How much impact is that having on the current backlog?
If the defendants aren't appearing in court, the court is not able to address the cases, and it's going to add to the backlog. So it's important to make sure that the individuals are coming to court so that we can address their case.
Okay.
I would disagree with those numbers. I have not heard them anywhere in the state, and I hate to have them out there.
The
actual
crime research groups
90%
shows about 83% show up.
But there's some person. Go ahead, Tom.
Yes, in Chittenden County, it is stark. I'm in the courtroom all the time, and I see 2 or 3 people show up, and many that don't, and a pile of warrants go out the door. And I'm also seeing them downstairs where I am in holding, And the law enforcement is bringing in one warrant after another, and that not used to be the case. It would be 1 or 2 a week, and now sometimes it's up to 7, 8 a day.
But it's not 90%.
So there's an issue there certainly. And so just to close this, just putting this a little back into context, we've talked a lot about backlog, important issue, and that underlies this. But really what we're talking about is accountability and having the consequences closer to when an offense has occurred. So there's some deterrence value that we have. So we have certainty and swiftness in having consequences. And as we go forward, we have now 3 different data points that we can continue to look at to monitor the progress, monitor how what you're doing inside your branch of government is working, as well as the resources we're giving to that branch of government. And, looking at the number of cases, looking at the disposition guidelines, and looking at the clearance rate. There may be some other things that we want to look at, and I think that possibly the state's attorney has some information that will tell us, for instance, how many unique individuals are taking up most of the time. That it seems like there are people with 47 cases, there are people with even more than that, and that's something that may be the 4th thing we want to look at to monitor the progress that we're making. So any parting comment, and then we'll turn to, you all set?
Other than we just so appreciate the opportunity and your interest, and really appreciate, I know many of you were at legislator days, which is, I think, the best way to tell and see.
They've been very valuable.
Yeah, so we're just really grateful for your interest.
So I appreciate that. So, and we're going to obviously have to not get through everybody, but certainly intend to get through the state's attorneys and the Defender General's office. I've heard from Jen Pullman that she can be rescheduled. I'll work with Senator Sears on whether we reschedule a joint hearing or if we just hear from these additional people separately. But we'll also try to get, I don't know if Commissioner Demmel's actually here. So yeah, we'll get to Commissioner Demmel as well, since he is here. But we'll start with Kim Leaders-Dumont.
Mr. Chair, it's okay if the state's attorney from Windsor joins me?
Ward?
Mine?
Yeah, sure, go ahead. Happy to have you, Ward. Thank you very much.
So I'll share my screen so you have a visual aid while I'm droning on at the start. Tim Leaders-Dumont from the Department of State's Attorneys and Sheriffs. With me is State's Attorney Goodenough from Windsor County, who's also serves on the executive committee. So he's one of my 14 bosses, but he's like a super boss because he's actually on the executive committee and directs much of my activities from both a policy and advocacy perspective. So I'm going to have this up on the screen just while I'm talking because we have, through the good work of State's Attorney Sullivan, and I will.
A little bit bigger, is that possible?
The glare, it's actually the glare, I think.
And I will also share this. Much of the members of this group have this.
You want to sit over here?
Maybe.
Most of the folks in this room actually have most of what I'm presenting. I've reformatted it a little bit, and I use the chair's PDF format instead of a PowerPoint slide for a couple of reasons. But I'll just zoom in a little bit so you can see how many positions there are. 14 state's attorneys. Zoom in a little bit.
And can you make that a little bit bigger?
Yeah,
there we go.
A little bit. So there's these are the number of attorneys in each of the county offices. You can see there's 14 state's attorneys and 58 deputy state's attorneys.
And just real quickly, do we have this on our?
I'm going to update this for you after the hearing, but most of the data concerning the average caseload you all have. That should be on the website. And I've been working very closely with Representative Squirrel from House Appropriations really since December, and with yourself, Mr. Chair, which was the impetus for us actually digging into some of the data. A few notes that the executive director and Annie Noonan wanted me to just share at the onset. But from our perspective, public safety has not always been, sometimes it's been a policy emphasis of the legislature, but not always a funding emphasis, particularly with prosecutorial resources. And so we really appreciate this opportunity and the opportunities that House Appropriations in particular recently during the off season have been granting us to talk through these issues. We think that we're all here today because Vermonters have been talking with all of you and with all of us. And State's Attorney Goodenough is an elected official for the county of Windsor County. And so he's a place that people go to when there's issues perceived or real or combination. And as a recent and current mayoral candidate said on the radio recently, data is important, but also if someone doesn't feel safe, that's also an incredibly important aspect of the work that we're all doing. And we do believe, based on the FBI data, that crime is on the rise in Vermont. There is some trending, and if you look back 10 years, there are some things that are not where they were and some things that are going up, some things that have remained consistent. But I will say that homicide is 160%, 166% on the increase since 2012. So just to provide a little context, state's attorneys handle 99% of the criminal justice cases, and the vast majority of family and juvenile cases, as well as some complex civil cases that really stem from criminal matters. As you can see from the slide, the average caseload of an attorney in our department at the county level dealing with criminal cases, criminal only for now, 299.15, so about 300. I talked with my colleague in Connecticut yesterday, the average there is 200. If you include family, criminal, and civil, chins, delinquencies, YOs, that our offices also staff, the number jumps up to 361. Victim advocates have different practices in different offices in terms of how they staff cases, but the average we arrived at through a survey was 665 cases per victim advocate. Those numbers from our perspective are not the numbers that we need to be at as a state to actually make progress on the backlog and to make progress in terms of what justice looks like in Vermont. Defendants deserve to know what that looks like. Victims deserve to know what that looks like. The public deserves to know what that looks like. And we have multiple community crisis points happening all at once. And as you said, Mr. Chair, we're at the end of the road. So by the time something gets to Mr. Goodenough's desk, so much has gone wrong way upstream, but we do have to reduce things. Reducing the time between the offense date, particularly for repeat offenders, and the consequence date, we see as a crucial part of the solution. All of our solutions should be aimed in that direction. So we would recommend that the legislature provide adequate resources to assist the department in reducing the workload, which is different from the caseload. The cases tell part of this story, but what they don't tell is the many unsolved, very violent crimes that we are investigating right now, the thousands of search warrants that we assist law enforcement on, 24/7, 365 law enforcement advice, where we often have to wake up judges, by the way, and sometimes a defense attorney gets called. But we're the first call when there's a dead body in any of the counties that needs to be either released or kept for further investigation by the medical examiner. I have seen many dead bodies here in Washington County when I was a deputy. It was a very eye-opening experience because it shows you just that point where so many things have gone wrong in the community, and it gives you a bit of a cynical view, to be honest. But in thinking about, I think, some of the reasons and talking with you, Mr. Chair, why we're here today, the research shows that to actually prudently resolve cases and dispose of them, it doesn't just mean guilty pleas. It could mean community referrals. It can mean alternative outcomes. To prudently dispose of cases, we need to have prosecutors not handling more than 150 felonies a year. We need to have prosecutors not handling more than 400 misdemeanors a year. Because that trickles down as well to the victim advocate group and to the administrators. Our admins are the heartbeat of our offices. They are often some of the longest serving staff, and without them, we would be nowhere. Our admins, I think about them, they have the close relationships with judicial assistants, and that is something that we really have seen being the heart of our department is our judicial, our administrators, our victim advocates, and certainly our state's attorneys and their deputies. But as noted, and I don't think we need to dwell on it, but one point is there's 80 plus pending murder cases being handled by our department right now. One was recently, I think there was 83 as of December 10th, one resolved. And it was that case that was the 83rd case. The AGO was doing a sentencing in Burlington. So now there's 82. I believe those are all with our department at the moment.
So I just want to make sure that I didn't miss. Did you say murder and attempted murder?
Murder or attempted murder cases.
Okay.
Murder, they would be categorized as having the murder in the charge. That's how we pulled the data. 211, so including the 80, 211 are what we would call, from working with State's Attorney Sullivan on some of the data, very serious cases. Aggravated assault, which may be charged as attempted murder in some circumstances, manslaughter, attempted death resulting in aggravated assault, murder, all into that category of sort of homicide related. 211 right now are pending as of December 10th. So moving along in the slides, I did want to note, as we're moving along, you can see the caseloads here, the averages, and I can make it a little bigger. Last year, we wanted to say thank you for the 5 deputy positions, the 2 legal assistants and the 1 victim advocate. We're filling those. We're doing our best to recruit, and there's some challenges in the rural areas. For example, in the Northeast Kingdom, it can be a challenge to retain staff for long periods of time, but we're doing our best on that. And I think prior to that, there was an allocation of 3 positions in 2016 or thereabouts. But again, by context, some of our neighbors are seeing lower caseloads and more resources dedicated across the criminal justice system, not just to prosecutors, but defense and to the judiciary. We're also seeing some issues, which I won't dwell on today, with the expert witness type budget, with evaluations where the initial evaluation is conducted by an individual contracted with the Department of Health. We need to bring them back often and at great cost, sometimes at hundreds of dollars an hour to our department. So we're going to flag that. Annie Noonan can certainly dig more into that when she appears in House Appropriations. So talking about all case types, not just criminal, because again, if you're looking at all case types, it includes CHINs, which you might have a neglect case, juvenile delinquency, a YO, et cetera. Looking at those numbers statewide, and again, we're including here because our work, the word inactive in the Odyssey system, the court system, we believe is a misnomer. A diversion case may be a diversion case now, but it could be not a diversion case tomorrow morning. An inactive arrest warrant for a felony is not inactive to us. So I wanted to stress that there's some misnomers, and it's not the fault of anyone, it's just some misnomers in the labeling in the system. But as of December 10th, from court data, looking at the whole picture, there's about 15,000 pending misdemeanors, 6,700 pending felonies, 99 fish and game. And as noted, as December 10th, 83 pending murders. There were 76 PCRs, which are post-conviction relief cases that we staff. There was an important one I wanted to note, nearly 1,500 CHINs cases relating to neglect. And I think that paints part of the picture of the types of trauma and cases that our department is dealing with, and that the Defender General's Office is dealing with, and that the Judiciary is dealing with.
Wait, can you say that CHINs number again? I'm sorry.
1,484 CHINs B neglect cases as of December 10th.
And all of those are cases, not individuals, correct?
So yes, they're cases in CHINs. The Judiciary can explain more about how these CHINs can sometimes have a spiral effect.
I didn't just mean CHINs, I meant globally, like all the things you're citing are dockets, not individuals.
These are dockets. These are dockets. And a docket for a criminal case could include 5 counts, 10 counts, et cetera. So one person could be charged in an information, as we call it, with 10 counts of a number of things. This is for all case types, and I'm not going to dwell on this because I want to focus on criminal for today. This is ranked by average caseload by county. As you can see, Lamoille 573, Wyndham 476, Franklin 450, Rutland 424, Orleans 402, and this data is on your website.
Yes, Representative Rachelson, then Senator Wachowski.
So if a case can't go and be tried because there's not a judge, is that one of the big contributing factors to these caseloads staying large? Like if it resolved? So I guess I'm just wondering how the judge shortage factors into your caseload size.
I would say it's not something just on the judge or the courts. It's a combination of things, and using an individual case as an example. Someone with a pending felony, and I think I thought of this earlier as you were talking about someone with all the repeated VCRs. I'll just go forward to this page on repeat offenses just because I think it's helpful. Senator Sears was talking about a gentleman he's acquainted with in Bennington County. You can see he's at number 2 here. These are the top 20 individuals.
I'm not acquainted with them.
The circumstances, with 47 pending dockets. So that could represent hundreds of counts. And as you can see, one of those, the lead case, was a felony. He may well get a trial. But if they're all pending misdemeanors, it's harder to bubble up. And that's not something that we would blame on any one part of the system. It's a circumstance that a violent domestic assault case may need to be more elevated in terms of need than someone with VCRs. We think that violations of conditions of release imposed by the judiciary should matter. It is a concern. There's about 4,500, and here's an interesting one, Senator Byhowski, counts of VCR pending as of this week. Those aren't dockets, those are counts. And I was trying to desegregate it, but later the judiciary sent that off this week, 4,500 individual counts of violations of conditions of release. So one I wanted to really dwell on, looking at criminal only, by our analysis and in part due to conversations with Representative Squirrel from House Appropriations, to get the average caseload statewide for criminal only cases, we would need to hire between 10 to 14 attorneys to get the average caseload down from 299 to 250 to 275, something in that range, which is still 50 to 75 more than our neighbors in the South, but 10 to 14 attorneys, something in that range. And I won't give you an exact number because Annie Noonan and John will work through that with House Appropriations and with Representative Squirrel. But I just wanted to give you a sense of the type of number that we would need to get the average number of criminal cases, ignoring family for a second, even though I hesitate to do that, and family and civil, 10 to 14. We also believe, and I wrote it down because Annie Noonan just texted me, that 6 victim advocates would go a long way, even though their cases would still be quite high, it would help. And we would go through the process that we go with the executive committee with states attorney good enough to say where they get allocated, because it's based on quantitative, but also qualitative and that process that we go through. And that's why there's a Department of State's attorneys and sheriffs to go through that simple budgeting process. We also believe that 8 administrators, just to finish up, would be incredibly helpful given the increase that may, with more trials, et cetera, but also the ongoing work that we have.
Senator Byhowski.
So the FBI data you're citing is through the end of 2022, correct? It is not inclusive of the preliminary data out about 2023?
I haven't seen preliminary data from 2023. And the year just ended, obviously. It feels like yesterday, but I don't know. I'm not sure when that data is going to be finalized. Mm-hmm. In speaking with our field, we feel that it has not trended down this year. We feel that it is maintained or stayed consistent.
Well, the preliminary data does not support that. It actually shows that crime across the board in 2023 is trending down across the country, including the murder rate in Vermont. We had 25 murders in 2022 and 20 in 2023, one of which was a fatal police shooting. So I don't know that we can count that in the same category as homicide. So even our own statistics in state, they are trending down.
I would like to see those statistics before.
Yeah, I'm happy to share the Vermont Public article that cites those things.
I asked early on in this meeting, we need to get legislative counsel to get us some accurate statistics on crime rates. I get emails from people giving all kinds of crime rates that I'm not sure are verifiable. So I appreciate the discussion. I wanted to ask about, and maybe Ward would be the best to answer this, the violations of conditions of release. When we set up in 2018 the changes in some of our bail laws, it was never the intention of the legislature to not have people held accountable. It was just the intention that not everybody needed to go to jail on a violation of conditions of release, that there was alternatives. Have we lost those alternatives where our only choice is on a violation of conditions or a new crime, our only choice is jail or ignore?
I mean, I would say, and I'll let the state's attorney answer that maybe from the practice in Windsor County. I would say the issue that you pointed out in committee last week and today, as well as just because a person is in the community and they haven't been arrested for a new VCR, a new violation of conditions release, doesn't mean that they're being compliant. And so the ones that actually come to us, there is a sense that they have elevated for whatever reason, they've elevated them, the circumstances, but the community resources are a huge part of all of this.
That's why I'm asking Ward, what in Windsor County, for example, which is full of resources compared to other counties, as I understand it, from the Windsor County senators. Got all these resources.
I'll check.
What choices do you have on a violation of condition beyond jail?
So, and just briefly, Senator, I'd love to come back to your point about data at some point, but on conditions, I'll give you an example of a case we had last summer, an individual who started to accumulate new criminal cases and accumulated over the course of the summer. It had significant substance abuse needs, was a clear driver of crime. And the crimes were almost all property crimes. They were thefts, they were larcenies, they were retail thefts. And we accumulated, I want to say, roughly 12 cases in approximately 3 months. And almost all of them involved different victims. And the tough thing was each of these cases involved a different victim who needed a victim advocate to resource them, who also felt impacted by this offense. Most of them were they were almost all misdemeanors. And but the cumulative effect of these was this sense from a number of these individuals that nothing was happening, that this person, they'd heard, oh, well, there's now 4 other people who've had their cars broken into or things stolen off their lawn. You know, why are now there a 5th and a 6th and a 7th person who are also being victimized like that? And somewhere through that process, our office had tried referring this individual through the Tamarack program, which of course the legislature set up and is a program our office utilizes a great deal. That had not worked and had not seemed to have any impact, and there wasn't engagement with that program. There were conditions of release imposed that included getting substance abuse screenings, providing proof of that to the court, and not using substances. None of those seemed to have an impact. There wasn't any compliance with any of those conditions. Again, no one was monitoring, but those things hadn't been filed. And then eventually this individual stole something worth about $20,000. And that felony charge with the other pending 12 cases resulted, and there were failures to appear in every case, resulted in cash bail being imposed. And previously it had been denied, and then eventually that was imposed. Within a few months of that person being held on that cash bail, all the cases had resolved. The individual was on a supervision structure with the Department of Corrections. And that included treatment conditions and compliance and all of that monitoring. So I use that as an example of, we tried the conditions, we tried the Tamarack program, and our office felt that we had no solutions at hand for those violations. And I think in the conversation around violations of conditions, there are violations and there are violations. You know, there are individuals who are driving because they have to get to work, right? And they have a suspended license and they have a condition that says don't drive. And this person is caught driving. I mean, that is a violation of conditions. There are also people who are contacting their victims from jail and trying to thwart the criminal justice system by purposely asking them to commit perjury, influencing witnesses' testimony, despite this being a violation of a no contact condition. So there's gradations of how serious a violation is, but it is, that is not reflected in statute. I think it's frequently reflected in how judicial officers feel about a violation, how prosecutors may feel about a violation, but it is difficult to see those gradations in statute. I hope that was not too long.
It helps because it helps.
The one thing I would just say on data, because I really appreciated your comment earlier, was there's a Mark Twain quote I love, which is there are 3 types of lies. There's lies, there are damn lies, and there are statistics. And I think this body, I hope that this body is encouraged to look at the idea of consolidating how it is getting data I believe, an institution that really should be tasked with finding that and maintaining it and have stakeholder buy-in from defender generals, from prosecutors, from judges, because you have a number of different stakeholders all coming to you today with data that is some of it accurate to some degree, much of it contradicts itself. And I think having a centralized repository that this body can rely on would also be an enormous help to us on the field.
And I just wanted to get through, and Senator, I do see your hand.
Yeah, I wasn't done before, but okay.
Oh, yeah, go for it. I don't want to jump the chairs.
Yeah, no, that's fine.
Sarah Bobsky.
To your point, State's Attorney Goodenough, I have concern with us putting that conflicting data out to the world and thus fueling the narrative that something is happening. So I do want to be careful about that. I did want to check in. You said there are 83 pending homicide cases. Those are not all from this year, correct?
So a pending case could be from prior years, certainly, as we know from the backlog.
Yeah, and do you have a sense of how, I'm trying to think of how to word this, like I just got called to jury duty for a murder case from like 2019. So how many cases are from what years? Is there a place where you have that, where you look at like there's 5 from 2018, 4 from 2019? I'm making those numbers up to be clear, not trying to fuel the data issue, but is there?
Yeah, it would just be in the court data, so we can easily get that for you. That's I don't think that would take long to find it all. And it's 82 now, I believe. But again, this was a December 10th data thing. We didn't have a data person in our department. Newsflash. So you're working with a deputy state's attorney that has done his best working with a state's attorney, Sullivan, to try to weed through the data. But we don't have a data team. A lot of other parts of this country do have people that just do data for prosecutors. Again, I won't talk about Connecticut because I'll just get jealous again. But the snapshot of pending data, I just want to run through this for a second because of what's been discussed today. I'm not going to say repeat offenders, but I'm going to say individuals where there has been more than 2 alleged incidents of repeated criminal conduct. That's 3,485 defendants, persons, representing 12,688 pending criminal dockets, which could be multiple counts, out of a total of 21,619 pending criminal dockets, resulting in a 58.68% of total pending criminal dockets, meaning a majority of pending criminal dockets are for individuals with more than 2 pending dockets. So I just wanted to state those could be felonies, they could be misdemeanors, they could be both. The failure to appear data as of December 29th was 5,023 roughly over the past 12 months. Retail theft dockets, again, and I think your question, Senator Vyhovsky, is great about dockets versus counts. There was roughly 1,600 retail theft dockets that were pending as of December 10th. And moving on to just the slide of disclaimers, essentially, right? So when you're looking at criminal only, again, it doesn't include a whole bunch of areas of our work. Case review, the active and resource-intensive work of unsolved cases and investigation-related activities, pre-charge and post-charge cases being monitored or that are pending, YO cases, juvenile delinquencies, CHINs, ERPOs, PCRs. It does include a bunch of areas that some people might say, is that active? Yes, and we say it is active. Active diversion cases, Tamarack cases, which can come back at any time, pending evaluations, nearly 400 as of December 10th that we sometimes have to litigate. ONH and OH cases, which bounce back and forth between notifications, violations of probation, working with Commissioner Demmel's staff on those, arrest warrants, which again, if it says an inactive felony arrest warrant, to us that's not inactive, or someone with 15 pending VCRs. Active, all the different categories of active is certainly a part of our work. The treatment court cases, those are actively managed. And if there's going to be an expansion of treatment court, which I think the majority of our state's attorneys would fully endorse, it would need to come with resources and potentially dedicated staff that get training and how to address those types of cases. And certainly pre-arraignment cases that are caught in a moment in time in the data that haven't been arraigned yet. That's a part of what we're dealing with as well. In some post-judgment cases, someone's trying to litigate an expungement. If someone is dealing with other circumstances that arise post-adjudication, those will still be a part of our workflow. This is a slide you all have at this point about the repeat offense data I just referenced. You can see by county, the only counties with less than 100 individuals that are not having 2 or more dockets are Essex and Grand Isle, our 2 part-time state's attorneys. The rest all have over 100, 740 in Chittenden, 372 in Orleans, and 454 in Rutland. Just a couple point outs there. And then this is the slide I showed the other day in your committee, Mr. Chair. But just as a snapshot of the top 20 individuals, there's the person in Wyndham with 74 pending dockets. Bennington, there's a person with 47. Chittenden, there's a person with 41. There's a few that spread across a couple of counties there. 14. And then looking at something I think will be kind of the most informative in terms of our needs. This is the criminal caseload. What you looked at before was all cases, and we've broken it down just by pending criminal. So you can see it's ranked by order of average caseload by attorneys in that office. And again, if you look over on the left, obviously every office has 1 state's attorney, and you can see the deputies in the other column there. And you can see the murder cases pending in each one of those counties as of December 10th.
So question on a couple questions. So just to be clear, on the murder cases, are those murder or are those also attempted murder?
It would include both.
Can you get a breakdown of what those are as well? I think
we go to the very end. We can go by county and serious crime. Sorry.
Okay. So that is in the data. You don't have to show it right now. I just wanted to make sure I understood.
So you can see, for example,
attempted and
just as an example, here's Addison. And you can see here are the ones that we kind of deemed death related. So we had 1 murder, 2nd degree, 1 murder, 2nd degree attempt, DUI with death resulting, and aggravated assault with a deadly weapon. So we have that by county as of December 10th.
Right, and we're going to have to move pretty quickly to Matt Valerio. But could you circle back around to explain how these challenges, staffing, resource challenges are affecting access to justice? I'll say that in a broad way, but also public safety.
And I'll give a brief comment on that, and then I would like to actually have the state's attorney make a comment on that. Just wanted to also flag, here's the caseloads for victim advocates. It'll be in your data. As you can see, the majority of our cases have victims. So of the 21,000 cases, about 18,000 are victim-related cases. The point you just made about decreasing the time, one thing is making sure, as the Chief Superior Court judge just mentioned, that if someone is picking up lots of violations of conditions of release, that we are somehow able to expedite that person so that we're decreasing and closing the gap, timeliness being one of the most important pieces in accountability, decreasing the gap between the date of the offense and the date of potential consequences. And so by whatever means we can do that, I think we need to focus on that, because it's not fair to the defendant, community, and victim if we're saying your excessive speeding case in the 5th time that you've excessively sped, in any of our communities with multiple VCRs, that your trial's in 3 years, because that's going to run up against the statute of limitations, as Senator Wachowski has mentioned now. State's turn.
I was just going to add, just to put sort of a face to some of it. So turnover in staff contributes to backlog, right? If you have attorneys who are covering 200 to 300 cases a year, the burnout rate can be quite high. If you have attorneys who are coming into an office and leaving an office, and each year someone new is having to get to grips with a case and speak with the witnesses, review the videos, all of that is just time that is being completely burned through. If you have that kind of turnover with your attorneys, I would say most of the attorneys I know in our department, they don't feel like they can take vacation time. They have vacation time, they accrue, they have sick leave. People don't feel they can take it because they have so many cases. And if you take a week off, you come back to, I hear it routinely, people say, I almost wish I hadn't taken this vacation because it felt good while I was gone. And now it's so brutal for the next month, 2 months, just getting myself out from under the hole I'm now in. So it's, I'd say that's a significant piece, and it contributes to backlog is if you have that kind of burnout and you have that kind of turnover. Also, certainly with the judicial officers that are being requested, we're actually fairly thin on staff that you can hire for attorney positions. It's really hard to find attorneys right now in Vermont, especially for a lot of our positions. certainly the salaries are competitive regionally. But again, if your lifestyle is one of constant burnout compared to a job that might be maybe less well remunerated, but is a better work-life balance, it's hard to maintain people. And also, there just, even if you gave us 20 new attorneys, we'd have to find people who could fill those spots. And we have a fairly limited bar. And I think we're at a place where, because of the changes in technology, because of the changes in filing, we've seen a lot of people retiring out of the legal workforce, and a lot of updraft effect, where you have attorneys who are now who are either appointed to the bench or who are taking jobs that are that are being filled in that updraft. So that is all an ongoing challenge, and it does create backlog. When you have 300 cases, and each of those cases can involve search warrants for vehicles, search warrants for phones, highly technical data, highly technical legal issues, mental health issues that may be significantly complex in even your most mundane criminal case. You might have an enormous iceberg of litigation that is under that. The complexity of that litigation is much higher than it was 20 or 30 years ago. And so all of those factors contribute to backlog. I will say, in Windsor County, at least, we feel we have mostly worked through what was our pandemic backlog, other than in our docket cases, where there is still some lingering effect in those cases because of the seriousness and the complexity of those.
So the one other thing we didn't talk about too much with you, and we got that from the court somewhat, you focused on the resource needs, which are great. But can you make a parting comment as far as and you just kind of mentioned one just now, Ward, as far as what you have been doing to try to get caught up on the.
Yeah, so one thing I'll just jump in is, at our annual training this year, we had a whole session on how to creatively dispose of large dockets, sometimes relating to only a few people. And there's a brilliant program that State's Attorney Tracy Kelly Shriver is doing in Wyndham. It's like a restorative day that she tells folks to show up on a certain day at her local restorative office, and they get their panel out of the way. The case is over with, and that's her exercising her discretion without it being sort of imposed upon her by others. Here's how I'm going to address what she's deeming to be folks that could benefit from this. And then she kind of knows, if they got their run through that, the next time she sees them, that accountability maybe comes into play. And at some point, it'd be great to have her talk about that program, but it sort of depends on the community resources. And you said at the beginning, I'll say it now, without equitable community resources upstream from us, our ability to dispose of things becomes very, very limited. And an example would be, in speaking with one of the counties of the Northeast Kingdom, they have a community justice center that's effectively part-time. And so the ability to send things to that community justice center is different than other counties. And I know a few folks in this room work at CJCs where there's a little bit more of that robust staffing, et cetera. So that's one means that we're doing it. But another thing is how we're thinking about persons involved, and low-level cases are the ones that are bubbling up, but a lot of times someone with many misdemeanors might have a felony that's attached. And so taking the opportunities, more trial days are helpful, they require resources. Taking the opportunities, striking while the iron's hot, is a really important concept. And sometimes when someone is detained, when someone is forced to come to grips with their prosecution, that's when, as the state's attorney said, that's when the music is being faced.
I'm just saying, so in Windsor, we were, I believe, the first county to restart jury trials in criminal cases. Well, I mean, I think we beat Washington by maybe a week. But I certainly returning to that was a major factor. We had a significant partnership with a number of judges, including in particular Judge Treadwell, who took a very active role in both making cases we're staying on for a resolution, essentially, not letting cases slip through the cracks. He was a very active judicial officer in that. And we did have a number of cases. We had cases that were dismissed. We had cases that we had to reach resolutions on that not necessarily every party was happy with how we got there. But, you know, it was really a rubber meeting the road and an intensity that was difficult to sustain, but yielded some outcomes in reducing the backlog we had. I would say that, you know, I did have proposals of dismissing cases that were X amount old. The difficulty with that we find is if you are going to tell everyone we'll dismiss your case if it's 2 years old, it's very hard for anyone to want to resolve a case with you between day one and day, you know, in the second year. But we did, I mean, we were, some cases were by litigation, some cases were by agreement, but we really were able to cut that down by having them stay on for trials and being willing to make deals that might have felt unpalatable 3 or 4 years ago.
Appreciate that. Thank you. Well, we do need to move on to Defender General and welcome you up to the hot seat, Matt. Appreciate you, Chair. Thank you very much. And this will obviously be an ongoing discussion on many of the different puzzle pieces that we're trying to shape together into an answer. Thank you for being here. Thank you for your patience as well.
I know how these things go.
Yeah, you've been here before.
I want to see if I can get my little PowerPoint up. I don't usually like using them, honestly, because I don't think people focus on the PowerPoint instead of what I'm trying to say, but see if I can get it going here. You need me to sign into this meeting, is that right?
I'll leave that to our technical people.
Yeah.
Yeah, we do need you to join the meeting.
Okay,
You have the link?
yeah. Just sit there like this. It is a little different.
I wonder how my wife did it.
Don't ask. Don't call her and ask, because you know she's not having it. Take a little.
Excuse me.
You should be able to share now. Trying to find the share.
Change. There we go.
Okay.
Do we have this on our website yet? I see that we do. Okay.
It is on, I gave it yesterday.
Yep, we do have it on our website if people need to see it closer.
All right. In any event, I'm Matt Valerio. I'm the Defender General, for those who I know everybody here. Interestingly enough, most of the numbers that I saw from the court and from state's attorneys are in the ballpark, very closely to what we see. I think there's some interpretation of the numbers that might look a little different from our office's perspective. I wanted to give you a little bit of understanding of kind of the history of the backlog and some of the data that the court provided is dead on with what we have. So I want to give you a little bit about the criminal backlog, the clearance rates, a little bit on juvenile cases, and then the pending criminal cases in public defense. Let me start, though, with just some broad understanding. Before the pandemic, the public defense system was effectively treading water, which is not a bad thing. That means we were effectively getting rid of not every county all the time, but on the whole, we were getting rid of the cases that came in both from a criminal, on the criminal side and on the juvenile side. We have a fair caseload in the Prisoners' Rights Office as well, but I don't think that's exactly what we're talking about here today. That's not there is a backlog there, but that's not what we're here to really talk about. So as we were staffed, that was a manageable caseload. During the pandemic, of course, the courts closed for 18 months to 2 years, depending upon what county it was, and trials were not happening in many of the bigger substantive dispositive hearings, motions to suppress, dismiss, and the like were not happening as well. And so we built up this backlog during that period of time. We open up, and then we see effectively this. This is kind of an overview from I'm going from last year to now, in what we would see month to month. And this matches up with court data. You know why? I got it from the court, which that's a good thing. At least if I got it from the court, it matches what the court presented. And there's some interesting things that I want to point to regarding this data. So if you look at the first couple of months from this, like the last 9 months, where efforts have been made to deal with the backlog. In March of 23, there were 18,700 cases that were considered part of the backlog. That reduced between March and April by 5,000 cases. Like it went down incredibly. We're making some progress here. We hit then, but then we saw an uptick. And so in May, June, July, in this period of time, we saw the backlog rise again to the mid 15,000 range and kind of stick there until you then hit August and September, when the backlog grew back to almost what it was in March. And so we again hit over the 18,000 mark. And then for the last couple of months of the calendar year, drop back down again. But basically, we've been stuck at the 15,000, mid 15,000 range ever since then. All right. So if you look at this as a kind of graphic, this is sort of what it looks like in dealing with and if you draw the line, you kind of draw it right down the middle. We've made significant progress on the actual backlog during the last, calendar year. I find there are some interesting things when you look at county to county where the issues are, and this is what kind of dovetails what state attorneys were saying. Typically in Lamoille County, we have one attorney up there. And we had somebody retire from the practice of law there. And when that person left, that one attorney had almost 700 cases. So I put I use that COVID ARPA / general fund money that, and put another contract in there, put another attorney in there. And you saw a reduction from 1,162 cases in the backlog down to 639, but you're still talking about over 200 cases per lawyer. The ones that made remarkable progress is what I'm kind of showing here. Rutland had a huge backlog. Rutland traditionally has a backlog. Terry Persons, having been there actually on the ground, Rutland always seemed to have a backlog of about 1,000 cases. And then efforts will be made. And this is during normal times. Right now, we're not in normal times. Right? But they made a good effort and got reduced their backlog from 2,690 to 1,929 during the course of that year. And Windsor County, as was indicated by the state's attorneys, almost cut theirs in half. And that's one of our very strong contract offices. And Judge Treadwell was there, and significant effort was made, and he ended up in a good situation. So progress is being made, but it is really small when you look at it on a statewide basis. And I did the math that you're talking about. Effectively, if we do what we're doing now with the backlog, it'd be like paying off your credit card by paying the minimum payment. And that would be like 34 years of payments until you eliminated your backlog. Unless we do something significant to get at the backlog, this is not a 2-year problem. It's not a 5-year problem. It's a decade. And things are going to happen during that decade. Just as, during this, we had COVID that created in large part the backlog, but then we've had floods, and there are things that are going to come up and draw need for resources away from dealing with the backlog, and we're going to be stuck in a backlog for a really long time if we don't get on it quickly. This is the criminal clearance rate data that adds up to what the court talked about, the 106%. Again, that's the issue that we have. It's not it's not under 100%, so we aren't going backwards anymore, but we aren't going forward very fast. And you can see month to month how certain things change during that period of time. But we've got to do better, or we're going to end up in a kind of a constitutional due process problem where people are going to have cases pending for many, many years.
Can I ask you a question on that, Matt? And then I do have a question from Representative Andriano. How are we not in a constitutional problem right now?
Well, we are, but we're at the beginning of it, not in the middle of it. We came out of a pandemic and we've devoted resources to try to address it. And right now, I'm spending in the range of $1.2 to $1.3 million a year on attorneys to effectively deal with the backlog. And this is what, this is kind of the result we get. I've got a whole bunch of issues that go into that whole thing. Number one, I will tell you that I believe right now that I have every attorney who wants to practice criminal law in the state of Vermont for the public defense system is hired. They have a contract, they're in the staff office. They don't exist. And in particularly in rural counties, what I've had to do is to send people from far out of county to go into Caledonia, Essex, Orleans, Franklin, and then whole other kind of issue south, where we have we've used all the attorneys that are available in the southern part of the state. So when we have conflicts of interest, which is a lot, because we have a lot of co-defendants in these various cases, particularly in serious cases, I've had to bring lawyers from Burlington down to Bennington, Wyndham, Rutland, Windsor to handle cases because everybody else has conflicts. At the same token, I've had to send lawyers from the south up to the northeast Kingdom and Lamoille County, the gateway to the Northeast Kingdom, to do the exact same thing because there are insufficient lawyers, number one, and insufficient lawyers that are conflict-free to handle those cases. This is compounded by an issue that I have where our normal contract conflict system, we had turnover and abdications, resignations, they left. Before we even talk about the stuff that's the contracts that are related to the backlog, we had a long-standing contract in Chittenden County I was not able to fill, long-standing one in Washington that I was unable to fill, and a long-standing one in Wyndham County that I was not able to fill. So that has happened since the beginning of this fiscal year. These caseload relief contracts that I have put in place that travel all over the state have absorbed, for the most part, these cases from the places where our normal contractors no longer exist. Okay? And so the 1.2, call it 1.3 million, more or less, that the legislature gave the Defender General's office in one-time money to apply to contracts has been used to address those vacancies plus the backlog that exists around the state. Now, what does this mean when you add the backlog into your regular caseload that you would have? When you're judging, one of the things that the court is looking at is how many cases are coming in and how many cases are going out, and that gives you the 106. The part that's relevant to the backlog is whatever amount is over 100. There's some that aren't. But within the staff system, we have 35 public defenders. They have an average pending cases per attorney of 174. Before the pandemic, the average was anywhere from, usually it was 75 to 95 per attorney. So it's doubled, and then a little bit. It was not necessarily good timing, or maybe it was good timing, that the ABA and the NACDL, National Association of Criminal Defense Lawyers, revisited the longstanding American Bar Association lawyer equivalent caseload standard and came up with a new standard during this past summer in July. And effectively, it cut in half the number of cases that a public defender should be handling adequately based upon the criteria. It's a very long report. I think some of you have seen it, 100+ pages and lots of data in it. The bottom line is right now, I used to be basically right within the standard of, and maybe we were a little bit above, of added caseload. This is what the state's attorneys were talking about, the 400 added misdemeanors a year, the 150 added felonies a year. And we were in the ballpark, maybe a little over the standard, but we were, before the pandemic, now we're not even close. And the prior standard was based on added caseload, but it didn't differentiate, for example, felonies. So it didn't differentiate, the old standard didn't differentiate between a felony unlawful mischief, like I put a brick through that window, and a murder case. They were both felonies, and they were counted as one of the 150 felonies that you were supposed to be able to take. There are some things that I've seen in the past period of years. So I hear what, and this is the interpretation side of what I hear from I was talking about with the state's attorneys. We don't disagree with the gross number of, like, for example, murders, right? I have serious felony units that handle murder cases. I've never seen more filings of attempted murder cases than I've seen in the last couple of years. And I personally, nobody else, just me, every murder case that comes in, I personally assign to serious felony units. So I read every single one that comes in. And I'm not saying they're necessarily wrong, but cases that in my 35 years of experience traditionally had been filed as aggravated assaults and even reckless endangerment cases sometimes, shooting a gun over somebody's head, are now being filed as attempted murder cases. I don't care what they file them as, it doesn't matter to me. But the bottom line is, when that happens, it implicates different resources for the Defender General's office. Because when attempted murders come in, they now go to serious felony units as opposed to an aggravated assault that would go to a other contract counsel like caseload relief contractors or assigned counsel conflict contractors. It implicates a totally different resource paradigm, basically much more expensive. Also a much higher level, for the most part, of attorney who do those kinds of cases. I checked our data. Now I don't know what around the state and other, we represent 85% of the people in criminal court, more or less. And so there's a 15% or thereabouts that either represent themselves, they're pro se, or they hire private counsel. But I couldn't see any convictions in our data for attempted murder in the last 5 years. So these charges that are being charged as murder cases, I wonder if they're really murder cases. They are aggravated assaults or something else that ends up getting charged and implicating these resources. I believe they're charging decisions that are made that to some degree inflate the murder, what we call murder under our statistics, because I'm not seeing it as far as, it's not lots of bodies.
Yeah, that was part of my question as well, for why I wanted to understand how many of those murders and attempted murders were attempted. Right.
And so, but it's a different perception of, and I don't know if it has to do with training or whatever. I can say where a lot of them have come from. You can see from Tim's slide, you see a lot of those being filed out. There's a lot that came out of Bennington. There's a lot of them come in the South. But they're everywhere. Bennington's remarkable, as it tends to be.
So we're going to have to wrap up fairly soon, and I don't think, unfortunately,
right now.
Yeah, right now, but there's one.
Yeah.
That's very soon. But I guess I do want to have you leave us with answering this one question, and we can continue. And we're going to talk about whether we need to have separate meetings for the additional witnesses that we might get to, or if we're going to have another joint meeting. But in any event, it's just, I guess the question is, given the budget restrictions and guidelines that you've been given from the administration, what do you actually need to just keep doing what you're doing right now, let alone trying to deal with cases coming faster? What do you need? What does the Defender General's office need as far as resources?
Well, I don't know, right? We don't have a hard number yet from administration regarding the governor's recommend. You know, there was a budget exercise that had us fill the budget to a 3% increase. That's pretty well widely known. But I don't know what the exact number is going to be. But I will say that any of the discussions at this point, and you know, I don't want to jinx anything. You know, maybe we'll see a significant change, but I think we're about $2 million short for providing the exact same service that we provided last year. No increases, but you know, you're talking about 1.3 million in caseload relief contracts that would go away. And there are positions that were filled last year that because of previously negotiated salaries, like with our bargaining unit, with our pay plan, with leases, and with contracts for primary public defense services are not fully covered by a 3% increase. So, you know, I don't know what the number is going to be because I don't have a final number, but it's anywhere from 2 to 2.2 million.
I appreciate that. So there will be obviously much more that's going to be done with this, and particularly with Trevor and the Appropriations Committee. But I think this day has really informed the Judiciary committees and those who are not on the Appropriation committees to allow us to, with good information, advocate for the proper resources for these different stakeholders. So
I do wish at some point, and I know, you know, I went last, so I got the 15 minutes instead of the half hour or 40 minutes. And that's the way it goes. But if you do want to talk more about it, there are a bunch of other issues that came up in other folks' testimony, particularly things regarding like drug court and other sorts of things that I would have loved to be able to answer those questions from the defense perspective, but I understand you're short on time. So I'm more than happy to come back in either committee and follow up. And if people have those questions individually, they should email me, contact me, or invite me to come in. And I'm more than happy to answer those questions from the public defense perspective.
certainly on the House Judiciary side, we will be having a session about treatment courts. And I know that we all will be dealing with VCRs, bail, and all these other issues, and definitely have you in or other folks from your office. So
one of the things just to chew on as a last thing, while we were talking here, I had my stats people give me the last 5 years of charges for violation of conditions of release. They've gone down, they haven't gone up.
Would love to see that.
So,
send that to us.
You know, clearly there's a perception in the public of something going on. But I don't think what's going on is what the public thinks is going on, because the numbers don't back up what the perception is.
Well, that brings us all back to the accurate statistics.
Right.
If I read the paper, it's only those cases that are egregious that show up. The 90 people that don't have a violation of probation don't show up, obviously. So we don't know. That's why I need the statistics.
All right, I really appreciate your time, and we are adjourned, and